Judge, I have a question on instructions.
Sure.
Jurors?
Not yet.
Not yet. So the definition of assault, I didn't see anything regarding burden of proof on self-defense.
Where are you looking?
Well, I'm on the side on your tablet here.
Yeah, but which section? You in instructions prior to voir dire,
Any of them.
procedural instructions, elements of criminal charge, final instructions, where you at?
Well, I was in elements and I don't see, let's see, elements.
Judge, there is currently no self-defense jury instruction in there. I also didn't include one for defendant testifying or defendant not testifying because I didn't know what was going to happen.
Yeah, those will be in final instructions.
Okay.
So yeah, counsel, I don't think you tried one here with me, have you?
No.
Okay, so the way we do it is at the end, we'll get together and
Okay.
decide based on what came in,
Okay.
what final instructions we might
All right.
need. Then Heather will update the tablet. Takes her 20 minutes.
Okay.
Right? Okay.
All right. No problem. That's
Good
all.
then? Bring them in?
Yep.
Okay.
Stand up for the jury's. Sit down now.
You know what I don't want? A list of jurors. Hey, do Nellie a favor and bring me a copy of the jury list, would you? Thanks. You get so stressed out for this. Ma'am, is it all right if I just refer to you as Lucille Evans?
Yes.
That's okay? Hyphenated names always throw me off. Thank you. So you juror number 24? No, just saw. Well, I just got the list. Good morning, folks. Have a seat. Have a seat. Look at how excited they all are to be here. That was something new called sarcasm. How many of you folks, seriously, how many of you folks were kind of looking forward to coming today? All right, that's unusual. Usually I get, yeah, there is one hand. You, reluctantly, right? Yeah, usually there's one, maybe two. How many of you folks, when you got your notice to be here today, thought things you wouldn't want little kids to hear? Now you're lying. Nobody was upset about jury duty today. Okay. How many of you folks have served on a jury somewhere? All right. Couple. Back row, man. Where at? Did you serve locally or downtown? Here? Okay. And once again, I want you to be honest with me, but it was a positive experience, wasn't it? Yeah. Okay. How about, sir? Where'd you serve? Downtown. Okay. Criminal or civil? Criminal. How long? 8 days. Okay. Not so positive, was it? Yeah, it's a big time suck. You lost money. Yeah. I have a friend of mine. I just talked to him last week. He went down. It was 4 hours before he made it to a courtroom. An hour of that was standing in the hallway. And he's a real easygoing guy. Not a positive experience. Although now they let you have your phone, so you know you can at least take care of some business and stuff like that. A couple hands over here. Who served? Ma'am, where at? Detroit. Criminal or civil? Criminal. How many days? 5. Yeah. Positive? All right. Okay. Yeah. Somebody else over here? Downtown. Criminal? Yeah. Okay. How many days? 2, not too bad. Okay, so here's the thing. I tell people all the time, some of you folks, well, all of you actually, you're all going to leave here at some point today, I promise you. Whether or not you serve or not, you're going to leave. And somebody's probably going to contact you, friends or family are going to probably contact you in the next month or 2, 3, whatever, and say, hey, I got a notice for jury duty. What do I do? Tell them if they got a notice for local, go with an open mind, serve. If you get a notice for downtown, take a good look, right? I mean, it is what it is. I don't understand. I really don't understand. I know part of it's just logistics. They're dealing with so many more people, but I just don't understand why it takes 4 hours to get a prospective juror into a courtroom. I don't understand that. And I hate it because it makes my job harder because so many people get where you're at and think, I don't want to be here. I don't want to be here. I don't want to be here because you've heard all the horror stories. All right, I can guarantee if you spend the day with us today, you will think it was more positive than negative. I can guarantee that. There's no doubt in my mind because I've talked to so many jurors after they've served, and I know my people. My staff understand that their job today is to make things as comfortable for you as we can because none of you really want to be here. Even the guy in the back that's like, yeah, maybe. And we also understand that we're asking you to come into a job that most of you, or probably none of you, have had any training to do, right? I mean, any lawyers, right? Paralegals, no. Yeah, so you don't even know our system, right? You don't even know the world you stepped in today. We know that can be uncomfortable for people, and we're asking you to do that job with people that you probably don't know. You put all that together, and it doesn't make a warm fuzzy when you walk in the door. So we recognize that. So you might have figured this out. I love this process because I get to talk to people that I don't get to see. Okay, I love this process, and I'm also a big fan of the jury system. I think our criminal justice system is a flawed system, but I also think it's the best one anybody's come up with yet. And I think this is part of that reason, the jury. You know, there are a lot of people in our 5 communities that think I'm a flaming idiot. Okay, so if one of those people get charged and end up in my courtroom, they shouldn't have to have me hear their case. They get to ask for you folks. Well, I hope Miss Evans doesn't think I'm an idiot. I hope that's not why she's having a jury trial. But that should be an option that folks who get charged with a crime have, okay? I just think the system's a great system, even though it's flawed. And I thank you for making this part of the system possible today because you showed up, even if you were reluctant, you showed up. So the way this works is my role is to make sure that whoever gets picked as an actual juror, when we send those folks in to deliberate, it's my job to make sure they've got the information they need. So the attorneys are going to provide evidence. I'm going to provide the rules, the law that you are to apply, and we're going to send you back into the jury room. I tell you this to tell you what's coming. The state of Michigan, in all of its wisdom, has 3 volumes of criminal jury instruction. Okay? Now, you're not getting all 3, don't panic. But part of the information, and much of the information you need to have today is out of those 3 volumes. And I'm going to provide that to you. You don't have to go look at it on your phone during break. I'm going to give you the jury instructions you need to know. Some of them I'm going to give you more than once. You're going to hear them repeatedly. To do that, because we're not big dollars here. We don't have the teleprompters, so I can act like I'm looking at you when I'm really reading a screen. We don't do that like the politicians do. So I'm going to really read a screen. And I'm going to get ready to start doing some of that now. And that means you're going to look at my forehead. And you might have figured out I would rather interact with you this way. Now I'm going to interact with you this way. So bear with me. Let's see. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us to choose a fair and impartial jury to hear the case. During jury selection, the lawyers and I will ask you questions. This is called the voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused from this particular case, even though you may be otherwise qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there's a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I'll now ask you all to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. Right hands, please. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? Thank you, folks. Have a seat. So I told you who I am, and I've got the high dollar nameplate. Over here is Heather Moorefield. Heather is my secretary recorder. Her main job out here today is to make sure that everything that's said on my side of the bar, which is that half wall between us, everything that's said up here is accurately recorded in case there needs to be an appeal or there's a transcript necessary for some reason. I want you to understand that for a couple of reasons. First, if you're up here and somebody asks you a question, answer audibly. Don't head shake it because she can't record a head shake. We might see an affirmative or a negative head shake, but she can't record it. So stick with the yeses and the nos. And by the way, I don't know is a perfectly legitimate answer to a question. The other reason I want you to understand that is if she gets more than one person speaking at the same time, both those voices are going into her headset. Both of those are being recorded, and it's a mess. So, for example, if I ask you a question, just wait that extra pause or 2 to make sure I'm done before you start the answer, because we can't have people talking on top of each other. Officer Krolova is assigned to our courtroom today. Some of the other guys may be in and out. If I give Joe a task and he's off doing something else. But the court officer's primary role is to make sure that things in the courtroom are safe. I don't expect that's a problem today. So his secondary function today, probably his most important one, is he's a conduit between you and me. So if, we stick you in the jury room and I don't know, there's no water in the fridge or the temperature in the room is too cold or too hot or whatever, let Joe know. We're going to try to make things as comfortable for as you can. So if you have any issues, let him know. Sometimes he falls asleep because he's been a cop for a long time, so he learned how to fall asleep while he was standing up. He usually doesn't, but generally speaking, he's keeping an eye on you folks in the jury. Okay, so if you need a break and you haven't caught my eye, just give him the mad eye until he acknowledges you, and we'll find out what's going on, and you can just say I need a break, right? Because we'll do that as well. I'm going to give the attorneys a chance at this point to introduce themselves and any prospective witnesses by name at least. Ms. Manor.
Good morning, ladies and gentlemen. Good morning. Okay, want to try it again? Good morning, ladies and gentlemen. Good morning. Awesome. I know you're all so excited to be here. But Judge Oakley's going to make this fun for us. My name is Patricia Mandernick. I'm an assistant prosecuting attorney for Wayne County, and I represent the people of the state of Michigan today. I think this is going to be a quick day for you guys. I have one witness to present today. His name is Clayvon Evans. Does anyone know Mr. Clayvon Evans? Perfect. All right, I will turn you over to Vince.
Now we get that practice. Good morning, everybody.
Good morning.
My name is Mike Kelly. I represent Lucille Evans. I work for the law firm Kelly and Kelly PC. As the name suggests, a family firm. I will mention that because my sister is a divorce attorney, and if any of you may have had contact with her on either side, let me know if that name is familiar to you. Ryan Kelly. We only have to be doing this, Kelly, today. We may or may not hear from Lucille. I appreciate you guys all being here, and I hope that you pay attention and just follow judge's instruction, and it shouldn't be too long. Thanks.
All right, so you've already heard that this doesn't appear to be a long day. So any of you have any reason why you couldn't stick with us for what I would say at most a business day, 4 or 5 o'clock this afternoon? Any time constraints there? All right, how about health issues? I'm pretty loud. Anybody having trouble hearing me? Okay. If any of you, everybody's not as loud as me. Mr. Kelly, I was happy to hear you're pretty loud. If anybody's speaking, once again, on this side of that bar, from the witness chair or one of the attorneys, if you can't hear, just let us know. It's like I can't hear, and we'll move people around, or we'll ask people to speak up. How about physical issues? Anybody have trouble being seated for too long? Back issues, leg issues, anything like that? Awesome. Okay. All right. That's great. All right. So I mentioned something earlier about a break. One of the downsides or upsides maybe of our profession is we tend to be able to sit for long periods of time, and we sometimes forget that real people don't like to sit for 3 hours without moving. So if that's your situation and it's like, man, I just got to move. Once again, just let us know. It's like, can we have a break? And that's a good segue into this. Whether or not we take breaks, we're going to take breaks because I can guarantee the process at certain times, the 3 of us are going to have to talk about stuff we don't want you to hear about, exchange recipes, whatever it is that we don't want you to know about. But other than that, if we break for lunch, that's going to be on you guys. So you decide if you want to break for lunch. You'll decide when we're going to break for lunch within reason. I mean, if you say we're going to break for lunch at 12 o'clock and we're almost done with a witness, I'm not going to say, okay, you just sit there. We're going to break for lunch now. But it sounds like this one's going to be fairly quick. So it sounds like we might be able to get this to final deliberations lunchtime-ish. So, right? Okay. So you might not want to break for lunch. You might want to just, drive on through and finish. But at any point, you guys are just like, hey, we need a break. Just let me know. We'll have that conversation. The attorneys and I will have a little group discussion. We'll figure out what we're going to do. Once again, I want to make sure that when you walk out of here, you can say, well, I don't want to do it again tomorrow, but it wasn't completely bad experience. All right, so let's move on with instructions. This is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges that the defendant, Lucille Evans, with the crime of domestic violence, as reads as follows. The complaining witness says that on the date of February 7, 2024, at a location in Van Buren Township, the defendant, contrary to law, you don't have that in there. Oh, here it is. The contrary to law did make an assault or an assault and battery upon Claiborne Evans, her spouse, contrary to Michigan compiled laws. This is a misdemeanor punishable by 93 up to 93 days and or $500. The defendant has pled not guilty to these charges. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think that it is evidence of her guilt or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that Ms. Evans is innocent. The presumption continues throughout the trial and entitles Ms. Evans to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances. Officer Crova, are you ready to pull names?
Yes, ma'am.
All right. Now, folks, Joe's going to call names, and he'll direct you where you're going to go. So, two things. Number one, if Joe mispronounces your name, the three of us are going to mispronounce your name every time we use it. So, if he does, please correct the pronunciation so we can all get it right. Number two, you're going to walk up between me and the witness stand here. There's an incline ramp there. It will trip you if you're not watching for it. And Joe and I will both try to remind you, but I'm giving you a blanket warning right now. Watch the incline ramp. With that, we're ready.
All right. Seat number one, Kona Patter Poirier. Yes, okay.
Did you get it right? Potter Poirier?
Mm-hmm. In seat number two, Kelsey Wack. Wow. Kelsey Wack.
I don't know. Different spelling. More.
In seat number three, Bradley Zarni.
Say it again, sir.
Zarni.
Zarni?
Yep.
Like Barney.
I'm sorry?
Like Barney with a Z? Zarni?
Kind of.
Should have wore purple today.
In seat number four, Lowell Gunning. In seat number five, Ryan Miller. In seat number six, Ryan Harper. You ready? And seat number 7, Jillian Bordeaux. Julia, I'm sorry.
All right, nobody tripped. All right, so folks, don't get too complacent yet. You're not gone yet. What I'm going to ask you to do is I want you to pay attention to the questions that are going to be asked of these 7 folks. Because if one of them gets excused for whatever reason, you might find yourself in that chair. And the first thing I'm going to say is, were you listening to the questions based on the questions that were asked? Is there anything that the attorneys and I should know about? Just to try to short circuit things. All right, with that, and this is, I'm going to ask this question of the group at large. Are any of you aliens? From that, I mean, do you all live in Belleville, Huron, Sumter, Romulus, or Sumter Township?
Yeah.
Okay. Last trial, where was that guy from? Wayne or something? It's the first time it's happened in probably 15 years. We had somebody in here that was not supposed to be here. We chastised him severely and sent him home. So let's see where we're at. All right. Any of you folks know any of the names that have been, you know, Officer Crova, Heather, me, attorneys, witnesses, anything? Any of you know anybody? Well, any of those people? Okay. It's a criminal case. You've heard that. So do any of you folks have close relations with law enforcement? Maybe a family member or close friend that's in law enforcement? Anyone? Let's start with Ms. Walker.
One of my best friends is state trooper.
Okay. Okay. Well, let me do this. I'm going to try something new. And sir, how about you?
My nephew's a police officer in Marquette.
Marquette. Okay. Did you have your hand up, sir?
No.
No? Just you two? Okay. All right. So the fact that you have close friends or family that are law enforcement officers, and they're not involved in this case, obviously, Marquette, right? Where's Howell? Okay. The fact that you have close relations with law enforcement officers, would that cause you to be less than fair and objective to either side? Maybe you don't like, you know, your law enforcement nephew in Marquette. I don't know. Would that cause you to be less than fair and objective? All right. The fact that you know law enforcement, you can just put that aside and just listen to the testimony and treat everybody the same. Yeah. Okay. What else do we have? Any of you folks have any criminal cases pending? As witnesses, defendants, have you been involved in anything in the past, criminal cases? Witness, victim?
Yes, I have.
Okay. And Mr. Dunning, right?
Dunning.
Okay, make sure I get my notes where they're supposed to be. Tell me more.
Okay, so I worked at a car dealership for a number of years.
Okay.
And
Where at?
at Dunning Toyota in Ann Arbor.
Okay. Okay.
And,
What a coincidence you worked there.
Yeah. But anyway, so someone stole a vehicle off
Sure.
our lot, and I didn't have to appear in court, but I just had to get a written statement.
Yeah. Okay.
So
All right.
that was it.
I'm going to correct me, but I'm going to guess that experience probably didn't color your objectivity.
No.
Okay. Anybody else? Any of you guys ever been involved with any kind of court stuff? Mr. Miller, right?
Yes.
All right. Civil case?
It was
Okay. Okay. Criminal case then?
yeah.
Okay. Any part of your involvement in that case that caused you to be less than objective? Are you catching the common theme here? Right? We just want folks that are clean slate. Okay. All right. Anybody else? Any involvement in the court system? Okay. All right. Let's see. We've already talked about who served and hasn't served. Any religious beliefs or just preconceived notions, strongly held personal convictions that make it uncomfortable for you to sit in judgment of a fellow citizen? No? Okay. All right. Any of you guys watch TV shows? Like, can we call them TV shows now, or do we have to say streaming? I'm going to still call them TV shows. You know, the court shows, the cop shows. I mean, I'm not the only one that finds those interesting. There's nothing else I can say. Well, that's not real. All right, so you've heard these phrases. I call them TV phrases, right? Presumed innocence. You've heard that. Today was not the first time you've heard that phrase, right? Okay. Reasonable doubt. Same. Not the first time you heard it today. All right. So we've heard these as a society. We kick around those phrases, and I think a lot of times with all phrases, we have different interpretations of them. You know, if I ask all 7 of you, what's your personal definition of phrase X, I might get 4 or 5 different answers, might get 7. So I want to make sure you understand what definitions we're using today. Okay, so presumed innocent to me, as weighty as that is, it's not a hard concept to understand. If you know, Joe and I had tea times at 10, which we don't because I don't golf. I think he tries. But if we had a tea time at 10 and I said, you know what, man, it's getting close. Why don't you go in there right now? Joe's going to take you back in the deliberation room and give me an answer. Is she guilty or not guilty? What's the answer going to be? You haven't heard any evidence. Any evidence. And that's simply all presumed innocent means. As she sits here right now, she is not guilty. She's presumed innocent because you haven't heard anything otherwise. Okay. Reasonable doubt. I'm looking at you folks, and I'm going to guess that every one of you have made what you consider to be an important decision or 3 in your life, right? Some of you have picked spouses. Some of you decided to get rid of those spouses. You bought homes, you bought cars, you've decided where to go to school. You've made important decisions in your life. Am I right? If you haven't, raise your hand and we'll have a conversation. How did you make those decisions? You gathered evidence, right? You put some facts together. You weighed the facts. You used your common sense and you said, I'm going to buy the Ford Escort or whatever you did, or Toyota. Hopefully for Mr. Dunning's case, it was a Toyota.
Thank you.
Right? But would you agree with me? That's how we make important decisions. We gather evidence, we look at what the facts are, and we use our common sense, and we just weigh things out. Would you agree that's how important decisions should be made? Okay. Now, the good news is you don't need to gather the evidence, right? We're, like I said before, we, the professionals, the lawyers in the room are going to give you the information, all right? So the prosecutor has to present evidence because it's her case. Now, it would be very unusual if the defense just sat there and played hangman. Okay, they can. Constitution allows them to do that. It would be pretty unusual. So although they might not present evidence, they're probably going to give you their spin on the evidence presented by the prosecutor. All right, but so my point is the evidence comes from the attorneys. I'm going to give you the law like I already told you. So we're going to give you the information. You bring the common sense. So we'll give you what you're going to apply your common sense to, and in that way you're going to make your decision. So reasonable doubt. You're reasonable people. If you have doubts after you weigh all that and apply your common sense, if you have doubts, they're probably reasonable doubts. Would you agree with me?
Yes.
Okay. And here's what I like to tell people. You think you know what my name is, right? Because I've got a nameplate and I've told you my name. Would it be reasonable for you to doubt that? Now, if I had said this, are you 110% sure that's me? You have no doubt. There's absolutely no shadow of a doubt that I am who I am, or who I say I am. That's a whole different ballgame than reasonable doubt, isn't it? Are you comfortable with that? Now, the last thing on that, the last thing I want to say is this. I think that creates a heavy burden for the prosecutor beyond any reasonable doubt. She's got to convince you of certain elements beyond any reasonable doubt. I think that's a heavy burden. She probably thinks it's a heavy burden. It is a heavy burden. And you might think, you know, that's not fair. She's all by herself. You know, she doesn't have a team of experts with her. She doesn't have 3 attorneys sitting in the row advising her. That's just not fair to her. It's too much for one person. Any of you feel that way? Are you okay holding her to that heavy burden? Okay. I'm done. I'm going to turn these folks over to you folks.
Good morning, ladies and gentlemen. Excellent, good morning. Like I said earlier, my name is Patricia Mandernack. I represent the people of the state of Michigan in this case. As the judge mentioned earlier, in this case, the defendant is charged with domestic violence. Has anyone here ever been a victim of, and I know this is a personal question, has anyone here ever been a victim of domestic violence? Okay, anyone ever had a close family member, friend that was a victim of domestic violence?
No.
Okay. Juror number 1, Miss Potter Poirier, right? Yeah. Okay, if I mess up your name, just let me know. Your current occupation is a nurse? Yes. Okay. Do you interact with domestic violence victims through your work as a nurse? Okay. Have you had any training on domestic violence victims or domestic violence? How to identify the signs or anything as a nurse?
We do have to take classes.
Okay.
2 years, so yeah.
Okay. And I'll come back to that in just, is there one way that a domestic violence victim has to present? Okay. And juror number 2, Ms. Wack? Walk, okay. Might have to correct me, just correct me. You're NP, correct? Awesome. Have you had any training on domestic violence?
Yes.
Okay. And do domestic violence victims always present a certain way? Is there one type of domestic violence victim?
No.
Oh, do you have to be a specific gender?
No.
Okay. And juror number 3, Mr. Zarni. Okay, not Barney. And you are not wearing purple, much to Judge Oakley's
Yeah,
disappointment.
because I think his coloration would work with purple.
I think you could work it. We're Romulus red. You're currently a project manager?
Correct.
Okay, what's your highest level of education?
16 years, so 4 years in college, I didn't quite graduate.
Okay, what'd you study in college?
Environmental science.
Okay. And you're currently married?
Yeah.
Okay, and your wife was in medicine, it looks like? What was her occupation?
She was behind the contractor desk at McBo's.
Okay. All right, and juror number 4, Mr. Dunning. You are retired and it looks like you own a car dealership?
Yes.
Okay. So you're a good salesman.
Some people say yes, some people say no. I don't know.
Okay, and you have been a victim of a crime. You had a car stolen from your lot in Ann Arbor.
Yes.
Okay, did that experience give you any specific opinions of police or law enforcement?
No.
Do you feel like the case was handled well?
Very well, yeah.
Okay, excellent. Was the car recovered ultimately?
Yes.
Okay. All right. And juror number 5, Mr. Miller. You're currently a consultant?
Yes.
Okay, what do you do as a consultant?
I have a franchise business consultant with.
Ooh, excellent. I like their pizza, you know, some people might fight me on that, but you know, a nice hot and ready is convenient. And what's your highest level of education?
4-year bachelor's degree.
Okay. And just to reiterate, did your previous encounter with police give you any specific opinions about police or law enforcement? Okay. All right. Ooh, and Ms. Harper, you, juror number 5, Ms. Harper, or I'm sorry, I can't count, juror number 6. Mr. Harper, oh my gosh.
Counting might not be the only problem.
Yeah. There's the stereotype that lawyers are bad at math is true. Where are you currently employed? Okay. And you have an associate's degree? Okay, what's your associate's degree in? I'm sorry? Arts? Okay. Any specific art medium?
I did go to high school, so college and high school program.
Oh, awesome.
It was like, I was going to business management.
Yeah. Okay. Good for you. That's efficient. And juror number 7, Julia Bordeaux. I'm paranoid about looking at first names. You're currently a secretary for Huron Schools?
Yes.
Okay. And your husband is a mechanical technician for Ford?
Yes.
What's your highest level of education?
Associate's degree.
Okay, and what's your associate's in?
Child
Child development. Oh, okay, awesome. What age do you work with?
elementary.
Elementary, okay. All right, some of my questions might seem silly, but I promise there's a reason. Hopefully I can be a little bit entertaining. Has anyone ever had a bad neighbor? Okay, juror number 1 and juror number 2, you're nodding. Okay, juror number 1, what was your bad neighbor? Or why were they bad?
Just being nosy.
Okay, how were they nosy?
I was having a chef put up on a small lot, and they just were happy about it, even though everything was fine, the beer was getting put.
They didn't like you were put in a shed?
Yeah.
Okay. And juror number 2?
I really haven't, I was just thinking.
Okay. All right. Anyone ever had a bad coworker? And this won't get back to your coworkers, don't worry. Okay. Juror number 5? Okay, what was your bad coworker?
Why were they bad?
Why were they bad?
Routinely late, minimal effort. Our teammates, including myself, are
Okay.
taking that slack.
Just everyone's favorite coworker behaviors?
Yeah.
Okay. So, let's go with the coworker. So say that juror number 5, you go into work one day and this coworker that you can't stand, you see a customer punch them in the face multiple times. And that coworker is getting wheeled out of your workplace on a gurney. Does the fact that you don't like has your coworker been the victim of a crime?
That scenario?
Yes. Okay. Does the fact that they're a terrible coworker mean that they can't be a victim of a crime?
No.
Okay. And juror number 1, going back to the neighbor, your nosy neighbor who can't stand this shed that you're putting up. Say she installs her own shed and another neighbor and you see another person come and burn down their shed. Has your neighbor been a victim of a crime?
Yes.
Even though it was ironically their own shed getting burned down? Yeah. Okay, even though you don't like them, they're nosy, they've still been a victim of a crime? So we can agree that even if we don't like someone, even if we don't agree with all their choices, they can still be a victim of a crime.
Yes.
Okay. And as Judge indicated earlier, this is going to be a quick case with one witness. If my witness testifies that they were assaulted, and if you, or I'm sorry, let me do this a different way. Say that I present 1 box of evidence. I have 1 box of evidence, or I'm sorry, let me start that. Say that I present you with 3 boxes of evidence, and I've got them sitting back there, all labeled. You know, this will be a multi-day trial, but I'm just not going to be here. I go through all the evidence. I have 5 witnesses, but you don't believe any of the evidence in those boxes, and you don't believe any of my witnesses. What's your verdict going to be? Not guilty, right? I haven't met my beyond a reasonable doubt burden. Okay, what if I have 20 boxes of evidence, 20 witnesses, and again, you don't believe any of it? What's your verdict? Okay, what if I only have one box of evidence, one tiny little, let's make it an envelope of evidence, one envelope of evidence, and one witness, but you believe everything that they say? Okay, why? Okay, so it's not based on the quantity of evidence, it's based on whether or not you believe it, correct? Okay. Judge, I have no further questions.
Thank you. Mr. Kelly, your panel.
All right. Yeah, that was the first thing I was gonna say. She's got a little bit more than an envelope. She's got questionnaires about all of you that I'm just receiving.
I just got into it, so.
That's all right, I was listening. Thank you, ladies and gentlemen, for being here today. I have a few questions that I'm going to ask you as well. Prosecutor talked about one person, one witness, but we may have a second person, may or not. Do you understand, all of you, that my client, Ms. Evans, has no obligation whatsoever to testify? Does everybody understand that? And you understand that she virtually has said everything she possibly could by entering a plea of not guilty. We understand that. Mr. Dunning, if my client chose not to testify, would you hold that against her? No. Mr. Miller, if my client chose not to testify, would you hold that against her? No. Ms. Potter-Poirier, would you hold that against her? No. Ms. Wack, I understand you're a nurse practitioner. You like to assess things. You like to have the information, but if you didn't hear from her, would you hold that against her? And Mr. Harper, how about you? And Ms. Bordeaux? All right. Mr. Zarni, same question. Let me ask you, Mr. Harper, what does the presumption of innocence mean to you? You don't have to give me some crazy legal definition. What does it mean to you? First, you hear presumption of innocence. What does that mean to you? Does anybody else have an additional or want to elaborate on that? Mr. Dunning, do you share that same definition of presumption of innocence?
Yeah, in general, I mean, it's up to the prosecutor to prove that person is guilty of what they're accused of doing.
And so how do we decide if somebody is guilty of doing something or not? Mr. Potter-Poirier, how would you decide?
Looking at the evidence.
Any particular evidence you'd be looking for?
Well, I guess the facts of the case, what actually happened to prove that it did happen.
And Ms. Bordeaux, you work in elementary education. So my wife's an elementary school teacher, so I bounced some of these ideas off of her over the years. And I have 3 young boys myself, and they don't always tell me the truth. So in this scenario, I can tell you this happened last week. My 2 boys are in the TV room. I'm outside, get back in from working out, I come in, and the TV, giant big screen TV, has a smash in it. And it's an immediate, he did it. And I try to get to the bottom of it. I try to ask these 2 young boys, what happened? As a teacher, or as somebody that's in education, you can appreciate that. But to this day, they still won't admit who did it. So in a situation like that, where you may have 2 people who are offering you varying versions, Mr. Bordeaux, how do we get to the truth then?
I turned over to these students and all the cameras.
It is a very hard decision. Go over what evidence there is.
Who else has children here? None of you? Mr. Dunning?
All grown,
All right, but there was a time, probably a similar situation might have happened in your house.
sure,
All right, and how did you get to the bottom of it?
investigate.
All right, and were you ultimately able to find one party responsible for the other?
Most of the time, but not all the time.
And do you guys understand that in this scenario, if you don't have enough to decide, and all you have is maybe Ms. Evans saying, I didn't do anything through virtue of my not guilty plea, what decision do you have to reach, Mr. Miller? All of you understand that? I know some of you mentioned that you had law enforcement in the family. Ms. Wack and so we have Ms. Wack, you had law enforcement as a friend, your good friend up in Hollis, state trooper. Okay. Has anybody had adverse interactions with law enforcement? Everybody stopped by her for a traffic ticket? No one here has been stopped for a traffic ticket? Okay. Mr. Zarni, you've been stopped for a traffic ticket?
Sure.
All right. Were you guilty of that offense?
Absolutely.
I won't get into your driving record, but anything about that experience affect how you might view law enforcement in this case?
No, although he did me a solid, so I appreciated it.
Has anyone ever had to call the police to their house?
Yeah.
Go ahead, you want to elaborate?
Just house alarm went off. Someone tried to break into my barn.
And Ms. Potter Poirier, I saw you nodding your head. You have had to call law enforcement to your house?
No, that was for the traffic.
Oh, but you've had a traffic ticket? We'll just ask, were you guilty of that offense? What was the offense, speeding or something?
Making right hand for, like, 5 minutes, yeah.
And Ms. Bordeaux, you said you've had to have law enforcement at your home before? What was the circumstances?
Somebody was breaking in.
What happened with that?
They were gone, thanks to cameras.
Yeah.
Township police acted quickly. They never got in. After that.
Does anyone feel that law enforcement, because they hold a certain position, are more trustworthy than other individuals? Swat, I see you nodding your head. Want to elaborate? I mean, how would you view law enforcement as being in maybe a more trustworthy position? Would it be fair to say that they're human like anybody else? Anybody feel differently if I say that law enforcement are, they're capable of making mistakes just like anybody else? Sometimes all we have to go on is the best information available at the time. And maybe there's no malice or ill intention. We simply are human, right? Does anybody ever, or do we know anybody or family member or friend who's ever been falsely accused of something? Not necessarily a crime, but just falsely accused. Have you or yourselves ever been falsely accused of anything? Has anybody ever accused you of doing something that was untrue? Pretty honest people. All the time. That's good. We understand that as part of this process that you serve as jurors, that there are people that are falsely accused. Do we understand that? Do we understand that as a function of jurors, you serve an important function in helping to exonerate people that are falsely accused? You understand that? So we accept and agree that even though we've got this court process, that there are a quantity of people that sit in this courthouse and many other courthouses across the United States that are innocent despite the allegations. Maybe I will look at this. How long have you been at here on schools for? Do you know Deborah Allen? My mother-in-law worked there. Just want to make sure you're not going to be. Just want to make sure there's no bias here. I'm betting the air. Where'd you go to school at?
Chamberlain University,
Where's that out of? Is it,
Illinois.
okay. Are you originally from Illinois?
No, that was for masters, for bachelor's, I went to Rochester University.
No children? Not yet?
Just a little curious.
Kind of fur babies. I'm sure you have a similar scenario of who done it with the golden retrievers. Okay, I don't have any further questions for you guys right now. Thank you.
All right. Do you lawyer types have any for cause excusals? Ms. Maronet?
No, Your Honor.
Mr. Kelly for cause?
None for cause, Your Honor.
How about peremptories from the people?
No, Your Honor.
Mr. Kelly, perempts?
Yes, one, we thank and respectfully excuse juror number one. That's about it for you.
Yeah. That's a faulty design. You should have had more room in that box. So juror one could get out. You know what? I'm gonna ask you folks to stand there just for a minute, just to save you some trouble.
Yeah.
Watch your step on the ramp, man. It does mean you can leave. You can also stay. But because you've been excused, you get the first lecture. When any of you leave, if you need a piece of paper that shows you were actually here today, then just, you guys got them at the kiosk, Ken?
Downstairs.
Downstairs, just check it security on your way out and they'll get you a piece of paper that shows you were where you were supposed to be today.
Okay.
Ma'am, enjoy your day. Would you, Gail?
Juror number one, seat number one will be Jacqueline Reed.
Ms. Reed, watch your step. And you get that front chair over there closer to Officer Crowley. That's why I asked you to stay where you were. Welcome, Ms. Reed. You were listening to the questions. Okay, yes? You were the first one I got on the head now. All right, so how about you? Law enforcement personnel, anybody, family, friends?
No.
Okay. Any personal involvement with the criminal justice system, either as a victim, as a witness, as a defendant, anything like that that we should know about?
No.
Okay. You heard me probably more than you wanted to talk about reasonable doubt and burden of proof. Did you agree with my definitions and how those are to be applied today?
I'm just gonna be honest with you.
Well, I would hope so.
I'm only here because I was ordered to be here. I'm not interested.
Okay, okay. Yeah, and I don't know that you're unusual with that feeling. Other than me and maybe a couple of the other staff members that are getting paid to be here, probably that's not a sentiment that's unshared. But let me ask you this. And I'm gonna ask you folks this question too, all right? This is actually my favorite question. If it wasn't Miss Evans in that chair, it was somebody that you loved with all your heart, would you want a jury member seated in the box with your mindset?
No.
Tell me why. The fact that you don't want to be here, you're going to hold that against her? I'm okay if you hold it against me because it's my order.
No.
And hear me, ma'am. I want you to hear my heart. I'm okay if you're mad at me because it's my order that brought you here today. That's okay with me. I just want to make sure you're not going to hold it against her or the people.
No, of course not.
Okay, and that's all I'm asking you to do. I'm asking you to listen to whatever evidence comes out, listen to the laws, I give it to you. Go back with whoever else might be serving to make that decision and give it your honest best. Can you do that? Even though you don't want to be here, even though you're only here under coercion, can you do that? Okay, that's all I want. And once again, I realize that everybody that leaves jury duty is not going to vote for me next time it's time. I understand that, and I'm okay. That's part of what comes with the job. But I don't want you sitting there today if you're not going to be fair to the parties. That's all I want. Can you do that?
Yes.
Okay, and I'm gonna turn Ms. Reed over to you folks for further questions.
Thank you, Judge.
Judge, may defense attorney briefly, please.
Sure.
Good morning, Ms. Reed. I know you are super excited to be here, as you said. Heavy sarcasm. I am just having a little bit of trouble reading the handwriting for the jury questionnaire. Just may I approach?
Yeah.
So, on your remarks, can you tell us what you've written? My handwriting is bad. I have no reason, no room to talk. No rush.
Yes, what is it? That's what I read.
Okay, so it's prejudice. Okay, thank you. We weren't sure. Why are you prejudiced?
I had so many incidents with, people saying things, throwing things off the car, just saying things you shouldn't say.
Okay, who does that make you prejudiced against specifically?
What?
Whites. Okay. Would you be able to set aside that prejudice?
Nope.
Okay. Nothing further, Judge.
Jacqueline, Jackie, either works. You don't even know me yet.
I don't.
Still? That's all right. Well, the judge kind of said, we talked about this. Do you understand if you were selected on this jury, that my client, Steele Evans, a black woman that I represent, that she stands innocent of what she's accused of? You understand that?
Yes.
It's my job to try to help vet out the facts so we all get a fair assessment of what happened. All right. And you understand that if she chooses not to testify, that she's entirely able to do so. And that doesn't mean she's guilty or anything else, right? And that if we rested and we went back and you deliberated and all you heard so much just us saying names, that she's exactly where she is, that not guilty, right? All right. You understand the prosecutor's burden that she has to prove is a very, very tall, very high burden that she has, the highest in the land, to prove beyond a reasonable doubt that Miss Lucille Evans is in fact guilty of the crime of domestic violence. All right. Thank you.
For cause from the people.
Judge, at this point, the people would like to thank and excuse juror number 1.
All right. Any argument, counsel?
No argument.
You'd agree?
Sure.
Okay. All right, Ms. Reed, you're excused from the box. You're not excused from my courtroom. Have a seat in the back. Officer Crowe, give me a name.
Jury number 20, Christine. Susan. Sorry about that.
Ma'am, would you say it again?
Saksuski.
Saksuski? Almost like it's a Z. Zuski?
Just
Saksuski?
like syllables, Saksuski.
Gotcha. Thank you. Makes it easy when you write it out that way. Have you been listening to the have you been listening to the questions?
Yes, I have.
Okay. So let's start with my favorite question. If it wasn't Miss Evans sitting in the chair, but it was your favorite loved one, would you want a juror in the box with your mindset?
Can you repeat that?
Yep. It's not Miss Evans. I'm assuming you don't know her.
No, I.
Okay. So it's not a stranger in the box anymore. It's somebody that you love dearly, charged with a crime. Would you want a jury box full of folks with your mindset?
Yes.
Okay. Is there anything based on the question that we asked the folks around you, like law enforcement, involvement with the criminal justice system, anything we should know about your background, we being the attorneys should know about your background that would help us maybe dig in and test you on your objectivity? Anything we should know? Okay. All right. Folks, I'll turn Ms. Saksuski over to you.
Good morning, Ms. Saksuski. Okay, if I get your name wrong,
You can just say Chris.
Chris, okay. If I say it wrong, again, just correct me. Do you have any pending civil or criminal cases?
No.
Okay. Do you have a pending probate case that you're involved in?
That should be closed.
Okay.
Good luck.
Pardon?
Good luck. It's a long process.
You can tell I don't have experience in probate law, just criminal. Has your experience with the probate lawsuit given you any specific opinions about courts? Well, more courts, not law enforcement. And then maybe they're a little slow.
Well,
Slow is generous.
been 2 years.
Okay. Do you have any prejudices against the court or the court system based on that?
No.
Okay. And you're currently retired?
Yes.
Okay, what was your occupation before you were retired?
I work for courts.
Okay.
I work for an attorney.
Oh, okay, you worked for
I got a
an,
good job.
yeah, very well-rounded. You worked for an attorney, you said? Okay, what type of law do you,
Family law.
family law? Okay. So you've seen a lot. So I'm gonna give you a quick hypothetical. Say you're home alone, you're sitting in your living room, there's a vase on the coffee table right in front of you. No one else is home, you don't have any cameras. Say that while you're sitting on the coffee table, a person breaks in and they're wearing gloves and they steal the vase. And then they climb out the window and run away. How do we know? So how do we know that the vase is stolen?
Because I said it's there.
You saw it,
Right.
so it was stolen in front of you, but we don't have fingerprints, right?
Right.
We don't have video,
Right.
we don't have any witnesses.
Right.
Does that mean the vase wasn't stolen?
No.
Does that mean that the person who stole the vase shouldn't be prosecuted and held accountable?
No.
Your Honor, I have no further questions.
Mr. Kelly.
Welcome, Chris. I'm just gonna get to the easy one. So your family law, you heard me mention my sister does family law. What firm were you with?
I only worked there for about a year.
Okay, where was it out of?
So,
Oh,
I work it out.
okay, name's not familiar with me, but I'm sure in that scenario, you probably had elements of domestic violence. No, okay, less contested, not as contested issues maybe.
Mainly it's what I worked on there is probate.
Okay, all right, that's a specific branch of family law. Okay, I got you. All right, well, you heard some of my questions before. Any different responses in terms of how you view law enforcement? What about, the presumption of innocence? What does that mean to you?
You're innocent until proven guilty.
And what about that scenario where my two boys are both kind of saying, yeah, neither one of us are talking? How do you understand in that scenario? All you've got is innocence, right?
Sooner or later, one of them will.
They might be 30.
Yeah, yeah, eventually. Let's hope so for the TV
I'm
sake.
not 38, I'm finding out things now.
Do you have children, adult children?
Yeah, well,
That's one, all right. And do you have any issue with understand that Miss Lucille Evans may choose not to testify? All right. Would you find it difficult to decide a verdict only hearing one side of the story?
Yeah.
And if you didn't hear from Miss Evans, would that affect your ability to render a decision?
no,
Are you just saying that?
no.
I'm just.
I'm gonna hear both sides of the story.
All right. And in this case, you may not hear from her side of the story, though. How does that change things for you?
So how would we reach for her side of the story?
Well, that's what we talked about. Is that you'll hear what you'll hear. And that may not include from Miss Evans. Does everybody else understand that? She brings up a good point. How will you reach a verdict if you don't hear from both sides? Mr. Miller, how will you reach a verdict if you don't hear from both sides? Ms. Bordeaux, you've been nodding, you understand? What do you got?
Because she already entered in that guilty plea, so she has already spoken and said what she needs to say.
Someone's been listening, I appreciate that. But that's a good question. And do you think then, with your position on this jury, as the judge said, I mean, we want somebody, if your 38-year-old son was in this position, somebody you care about, you'd want somebody who understood exactly what they're supposed to be doing and not doing in that seat. Do you still feel like you can do that, even if you know you may not hear from Miss Evans?
I can't say that 100%.
I understand. I appreciate your honesty. Thank you. No further questions.
For cause from the people.
Judge, the people move to thank and excuse juror number 1.
All right.
No objection.
Thank you. Ms. Exuski, you are excused. Same thing. If you need a note,
No.
check with the security guys downstairs. And feel free to stick around if you'd like to.
Juror number 4, Land, you?
Louis, like this.
Oh, you, okay. Land, you.
I never would have gotten that either, that pronunciation, so you're okay on that.
Thanks, Judge.
Good morning, man. Which is silly because it's exactly what it looks like, right? All right, Ms. Bowie, you've been listening to the questions, right? Very presumptuous of me, I should ask. My favorite question, the mindset you're carrying right now, would you want a jury full of that mindset if it was your loved one in the chair?
Yeah.
You're fair and objective.
I believe so.
Okay. Any law enforcement personnel that are close to you?
No.
All right. Any prior experience with the criminal justice system?
A medical malpractice case when I was a resident, that they just gave me because I was in the room.
Yeah, it's a shotgun approach, right?
Yeah.
Yeah, okay. All right. And I'm gonna guess by the play on your face, that was probably not recent.
No.
That was a while
Or the
ago.
gray in the hair. Yeah.
Okay, that was not recent. Okay. Anything about that malpractice suit that would cause you to be less than fair and objective to prosecution or defense?
No.
Okay. Just cut to the chase. Anything you think we should explore a little bit?
Not that comes to mind.
All right, I'm going to turn Ms. Bowie over to you folks.
Thank you, Judge. Morning, Ms. Bowie.
Good morning.
You are well, you said that there was an incident during residency. You are a physician. Awesome. What specialty?
OBGYN
OB-GYN. Okay, perfect. Where'd you go to med school?
in Iowa.
Okay, and where do you currently work?
I private practice in Kansas, Michigan, and I do some recent surgeries out of Beaumont/Burwell, Dearborn.
Okay. Are you familiar with a Mr. Karthik Ramaseshan? Okay, my husband is in medicine.
Oh,
I'm paranoid. I want to check because I know they send him to so many different places. And your husband works as an appraiser? Okay. And being an OB-GYN, have you received any specific training regarding domestic violence?
yes.
Okay.
Part of our medical education.
Okay. Is there, and I've asked this question already, is there a specific way that a domestic violence victim has to present?
You know, we'll do present a variety of things.
Okay. Have you or anyone close to you ever been the victim of domestic violence? Okay. Judge, I have no further questions.
Mr. Kelly, questions from Ms. Bowie? Dr. Bowie?
Okay, Ms. Bowie, how you doing today? Yeah, you still staying with us? You know, we're just getting started, right? Everybody comfortable still? This is like your first test, first check-in. Get out now or come up with some, you don't like me for whatever reason. But I'm glad you guys are all still here. Just a few questions from Ms. Bowie. Do you understand the position that I've been putting forward about if my client doesn't testify, do you promise not to hold that against her? Okay. And what does the presumption of innocence mean to you?
It means that she needs to present enough, or witness have to present enough to convince us that the defendant is guilty.
So good. So right now, how does my client stand to you? What is the status of her case?
Not guilty.
And if at the end of this case, you're not convinced that whatever was in that little envelope of evidence meets that burden, how does my client stand? Thank you. No further questions.
All right, for cause? Ms. Maronek?
None for cause, Your Honor.
None for
Kelly?
cause, Your Honor.
And peremptories from the people?
None, Your Honor.
Mr. Kelly?
Just one. We thank and respectfully excuse juror number 5, Mr. Miller.
It's always the inside seat. Feel free to stick around, Mr. Miller, or leave. Your call. Your call.
For seat number 5, Gary Johnson.
You just love those easy ones.
No, I love it.
I could see your tail wagging. Welcome, Mr. Johnson. Watch your steps, sir. Mr. Johnson, guess what I'm going to ask you?
Favorite question?
Yes.
Okay.
What's the answer?
Yes.
Okay. All right. So you've heard all the questions that we've all been delving into. Is there anything that we should explore further? Relationships with law enforcement, interactions with criminal justice system, anything?
No.
Okay. All right. Folks, Ms. Maronek?
Okay.
All right, Mr. Johnson, good morning. Okay, tell me honestly, on a scale of 1 to 10, how excited are you to be here?
It's moved up to very much stuff.
Because Judge Oakley's so awesome and entertaining?
I'll take it.
Good, good.
I got to know what the comment was now, so share that with me later.
I
You
will.
obviously put something on your questionnaire. Go ahead, Ms. Mandrack.
All right, so the comment on your questionnaire, I'm not worried about anymore. So you currently work for Rocket Mortgage?
Yes,
Okay, how do you like Rocket Mortgage?
I love it.
Okay, very fast paced?
Yes,
Okay, and you have an associate's degree?
I do.
What's your associate's in?
Arts and communication.
I'm sorry?
Arts and communication.
Arts and communication, okay. And your spouse works as a recruiter?
Yes,
Okay, how long have you been married?
3 years in October.
Okay, have you or anyone close to you ever been a victim of domestic violence?
No.
Okay. Judge, I have no further questions.
Okay, Mr. Kelly.
Mr. Johnson, how you doing?
Good.
I'm glad that the show has been progressing for you and we have more of a captivated audience here. Let me just see. You have 2 children.
Yes,
Okay. What are the ages?
6 and 5,
Boys, girls?
2 girls.
2 girls.
Good luck, Dad.
Yeah. All right. Well, you heard my scenario about 2 of my boys. You've had something similar with your kids?
Oh, well, yeah, I was wrestling with them when you said that, for sure.
So what did you do in that case to try to get to the bottom of it?
I mean, as far as really, I gathered as much information as I could, in that scenario to, make a decision, but like I think one of the jurors said sometimes you just can't, can't call.
Right? And in this case, you may not have both sides available to get information from, and you still have to make a call, right? And everyone so far before you, we've all come to understand what that call has to be, right? And so after you hear, if it's only from Mr. Claiborne Evans and you don't hear from Miss Lucille Evans, you can't hold that against her, correct? Have you had any adverse interactions with law enforcement?
No,
Have you ever had come in contact with them through a speeding ticket or a civil citation?
yes,
Right? Anything that you dispute about that experience?
no, sorry. Pretty much that. Gave me a trouble with.
All right. And do you place law enforcement in any higher position than an average citizen in terms of getting things right and wrong?
No,
That their position doesn't make them necessarily more qualified in judgment calls all the time, right?
no, yeah, you're right. No.
I don't have any further questions.
Okay. For cause,
None from the people.
Mr. Kelly.
None.
And peremptories from the people?
No, Your Honor.
Peremptories from Mr. Kelly?
I think we're set, Your Honor.
We have a jury. Okay, now you folks can smile. Now you dodged the bullet. So a couple of things I want to tell you. Number one, I want to remind you, if you need a note to show you were here today, that you can pick that up at security. The other thing I want to tell you is we love visitors, okay? Especially we're almost approaching summer vacations, and some of you have kids or grandkids that you're gonna have to be worried about entertaining. What is it, 3 days into summer vacation, they start coming to you and say they're bored. So bring them up here. Not every day, but a lot of days we've got live stuff going on in the courtrooms. You can actually check that out on our website. If you go to 34th District Court, just Google 34th District Court, you can find our courtroom schedules on the website, and they'll let you know what's going on. If you want to bring them in, just when you come to security, just say, look, I just got a couple of kids here just for a field trip, see what's going on. And depending on what is going on, depending on how busy it is, how many bodies we're shuffling around, we might give you a little tour. We might let the kids go in the jail cell and feel that shiver up their back when that door shuts behind them. I don't think that's a bad thing. Of course, I tended to parent with fear, but we won't leave them in there. We've had parents just beg us, don't let them out, don't let them out, but we always let them out. But we do like visitors, and every once in a while, I'll look up and I'm like, I don't have a file in front of me and you're still out there. What are you? I'm just here to watch, Judge. Sometimes retirees just come in and they like to watch court. Not so much now that you can watch so much of us on Zoom, on YouTube, but we do like visitors. So with that, feel free to stick around or take off. I'll let you go now.
Thank you. Thank you.
Jeremy, enjoy your day.
You as well.
Say hello to the girls.
Thank you.
Jeremy's wife worked here for how long? 10 years? Yeah. 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 Cute kids. Yeah. Okay. All right, folks, I need to swear you in. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and to reach a true verdict. Stand, raise your right hands for me, please. Do you folks solemnly swear or affirm that in this action, now before the court, you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court?
Yes.
Thank you. Officer Krova, do you swear that you will, to the best of your ability, keep sworn? Oh, you guys can sit down. I'm sorry. Best of your ability, keep sworn jurors in some private place, that you will not allow anyone to speak with them, and that you will not speak with them except under the court's order. And specifically, you will not ask them if they've reached a verdict, and until they are discharged, you will not communicate to anyone the state of the deliberations or the verdict they've agreed upon.
I do, so help me God.
Thank you. Now, do you folks need a break, or are you ready to keep going? You want to take a break? All right, Joe, let's give him a break. Folks, you can leave your stuff here. You can take it with you, whatever makes you comfortable. Joe's going to take you back into the jury deliberation room. There's water in the fridge. There's a bathroom there. We'll get started when you get ready to come back in. You guys take a break. Yep. Joe, let me get up first. Yeah.
probably the trial, probably the. Talking about the case and that was so hard. She's gonna have to work on like. You. Come back.
She gets gonna hang out.
Well, at least till lunch.
Did you guys need a water or anything?
No, I'm good, thank you.
All right.
Jeremy said it very nice. Jeremy said it very
All
nice.
right, the jury.
Straight to practice. Have a seat, folks. All right, jurors, I can call you that now because I've sworn you in. I get to read to you some more, so bear with me. I'll now explain some of the legal principles that you will need to know and the procedure we will follow. A trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes hers, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. To prove the charge, the prosecutor must prove the following beyond a reasonable doubt. I thought we were going to insert the elements there. You know what I mean? No, so I got to back out. No big deal. I got to back out and go to the section. That's all right. It'll just show up in your job. It's only fair. It happens to you. Elements of the crime charge. The defendant is charged with domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Claiborne Evans. A battery is the forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Claiborne Evans' will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Claiborne Evans reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Claiborne Evans was the defendant's spouse. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all her evidence, the defense attorney may also offer evidence, but does not have to do so. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor or defense lawyer may make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. Let's do that now. All right, Ms. Watt, do me a favor. You take the tablets, pass those around. And Mr. Zarni, if you'll take the notepads and pass those around, you don't get paid any extra for this. You just get a little gold star. The budget's tight, so you just get the gold star. All right, so folks, the notebooks and the tablets are for you to use or ignore. To you completely up to you. Now, I'm a visual learner. So if I was in your chair and there was a judge up here just reading jury instructions to me, my eyes are going to roll back in my head and I'm going to zone out. Okay. And I'm going to tell you how to get there. You can follow along with what I'm reading I go through the jury instructions in that tablet. I think it's pretty intuitive. If you go to the front page, it has jury instructions. We're currently in, let me make sure I can tell you where we're at. We're currently in procedural instructions. And I'm at page 3 at the bottom of the page, item 7. Same with the notepad, all right? When I do bench trials, I take notes, okay? So I don't expect you to just remember everything you want to remember. Take notes if you want to. But once again, some people find note-taking and reading along to be distracting. If that's you, don't use those materials. It's completely up to you. The other thing about the notepad, that steno pad that's in front of you, does anybody do, is that a thing anyway? We're old enough to know what a steno pad is, but poor Mr. Harper probably doesn't know what a stenographer is. Okay, it's an old thing. It's like Xerox paper, what's a carbon paper, right? It's like, yeah, mimeograph. It's an old thing. You're not missing a thing, Mr. Harper. So, all right, Ms. Watt just found it. In that notepad, there's a form that you can use to ask questions of a witness. So, prosecutor's going to put a witness on the stand. Prosecutor's going to ask questions. Defense attorney's probably going to ask some cross-exam questions. All right, they're going to go back and forth, and then they're going to be done with that witness. If there's still a question in your head that you think you need to know the answer to from that witness, you can raise your hand or catch Joe's eye, whatever, say, I've got a question, and I'm going to say, write it down. Joe's going to pick up that piece of paper from you. He's going to show it to both of the attorneys. He's going to bring it to me, and then the three of us will probably have a little conversation, sidebar conversation out of your hearing, and we're going to decide a couple of things. Number one, whether or not the question is designed to elicit admissible evidence. So, for example, I'm trying to think of something silly. If the question is, we want to know what the witness had for breakfast that day, and there's absolutely no indication that that would be important to the facts of the case, I'm probably going to say, no, we're not going to read that question. So the attorneys are going to look at whether or not it's after good info, and then we may decide that the question has to be tweaked a little bit to make it more clear or to elicit that information that we think is reasonable. If we arrive at a good question, and maybe that wasn't the right phraseology, a proper question, then I will actually ask that question of the witness so the witness can answer and then move on, okay? If I don't use the question, I'll explain it to you later why we decided it wasn't a proper question to ask. And that'll happen after the trial, of course. But that gives you the opportunity to get questions submitted to the witness, or at least submitted to us, so we can decide whether or not the witness gets it, okay? So we're back on page 3, paragraph 7. You've been given a written copy of the instructions I've just read to you. I'm sorry, tangent alert. I'm also going to let you know that before final deliberations, these instructions will probably be tweaked. Certain evidence comes in during a trial. It's like, oh, we need an instruction about this, or we don't need that instruction because that's not the way the evidence came. So the attorneys and I will kind of last minute go through final instructions, tweak them so they fit the actual trial we had, not just they could have fit. And the tablets will be updated so that when you get back into, well, actually, when you sit there to hear me give you final instructions, you can read along. And then when you go back into the deliberation room, we're going to let you take your tablets with you. So you can say, what did he say about that one instruction? You can go right back to what's in the tablet. All right, so back to paragraph 7 again. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end. At the close of the trial, I will provide you with a copy of the final instructions you are to use during deliberations. Moving on, functions of the court and jury. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make the decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. Moving on to page 4. It's your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that my only reason would be to ask about things that may not have been fully explored. Page 5. I'm going to skip over that. That's just to explain what I just did about your notes. If you want to have a question. Objections. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with the case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. Page 6. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you're not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with this case. It's very important that you only get information about the case in court when you're acting as a jury and when the defendant, the lawyers, and I are all here. Do not go to the scene of the alleged crime. Do not investigate anything about the case on your own or make any experiments. Do not search the internet on your phone to assist in understanding the evidence in this case. Note taking allowed, I've already explained that. Number of jurors. You can see that we've chosen a jury of 7. After you've heard all the evidence and my instructions, we will draw lots to decide which one of you will be dismissed in order to form a jury of 6. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rule of law that apply to this case. Then you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to keep an open mind and not make a decision about anything in this case until you go to the jury room to decide the case. Are we ready for openings?
Yes, Your Honor. Good morning, ladies and gentlemen. We are here today because on February 7th, 2024, at about 8 p.m., defendant Lucille Evans assaulted her husband, Clayvon Evans, by snatching his cell phone out of his hand, trying to immerse the cell phone under the water, Ms. Evans then followed Clavon Evans back to the bedroom. She slapped him across, or she struck him in the face. She pushed him on the head. And this caused both parties to fall back onto the bed in the guest bedroom. Defendant, Miss Lucille Evans, then bit Mr. Clavon Evans on the wrist. And she grabbed a gold chain that was around his neck and broke it during the altercation. At the beginning of the incident, and this incident happened at 43685 Forestdale Drive in Van Buren Township in the county of Wayne. Mr. Evans is going to testify that at the beginning of the altercation, defendant was telling Mr. Evans that he was going to go to jail. She's going to call the police on him. She's going to get him sent to jail. You're going to see pictures. And also during the struggle in the guest bedroom, the defendant pushed over a shelf, causing multiple items to fall onto the floor. And also the defendant grabbed Mr. Evans' glasses off of his face and causing them to break. Mr. Evans is going to testify as to what happened. Additionally, you're going to see, I anticipate that you will see pictures of the guest bedroom where the altercation happened. You're going to see the shelf that was pushed over. You're going to see the glasses that are on the bed. You're going to see the broken chain. You're going to see pictures of the redness on Mr. Evans' face. And you're going to see the bite mark on his wrist. Now, the judge just read you a bunch of jury instructions. And one of those was about evidence, right? So the instruction I want you to pay attention to is testimony is evidence. I'm going to say that again because it's so important. Testimony is direct evidence. So we talked earlier about, well, I won't get too much into that. So Mr. Evans' testimony is going to be supported by the pictures. Mr. Evans will testify that he was married to defendant at the time of the incident. And you will also hear that the parties were/are in the process of going through a divorce. And I do want to, we're not here to litigate the divorce. We're here focusing on what happened on February 7th, 2024 at about 8 p.m. at that location in Van Buren. It's up to you as the finder of fact to determine what you do and do not believe. But I believe that after listening to Mr. Evans' testimony, after seeing the pictures that support his testimony, I believe that you will find defendant guilty beyond a reasonable doubt. Thank you.
Thank you, Ms. Bannernet. Mr. Kelly.
Yes,
Opening
Your Honor.
now.
Yes, Your Honor. All right, everyone. I'm going to take you back a little bit further. On September 1st, 1984, Clavon Evans is then age 38. Lucille Evans is age 23. They're married. It's a 15 years difference here. Fast forward 40 years to the date of this offense on February 7th, 2024. Clavon is now the age 77 and Lucille is now the age of 62. And they're on the cusp of divorce. They share a home together at 43685 Forestdale Drive in Van Buren Township and perhaps have lived together as strangers for too long. At the time, each has a separate bedroom. Lucille had the master and Clavon had the guest room. Both are on the second floor. Clavon had begun spending time away from the home, often overnights, and this naturally piqued his wife's curiosity when she saw the joint bank account being used at local motels. On the days leading up to this incident, the couple was feuding. On the morning of February 7th, Clavon entered Lucille's separate bedroom, taunting her of his impending claim for divorce and promising to take everything from her. This culminated in Lucille taking an action of taking his phone and teasing him for having his phone. Well, as you can imagine, nobody likes to have their phone taken. And Claiborne was enraged. Lucille retreated downstairs with the phone to the first floor and ran into the bedroom in an effort to try to view the phone to see and maybe confirm her suspicions that he was doing something more than just taking the nights out. Claiborne charged after her, following her downstairs. She didn't have time to lock the door. He used his shoulder to push it open, causing physical contact with Lucille. There was no running the phone under the water. As you'll hear later from his own testimony, he was able to have his phone downloaded and update later on in the day, while police are there asking for pictures that he took. Claiborne still didn't have his phone back as Lucille was able to wedge her way by and ran back upstairs with Claiborne in quick pursuit. She managed to make it upstairs, and the most direct path she could go was right into Claiborne's room. She didn't have time to go around the corner to get into the master. Claiborne continued after her. She thought and hoped that once she was in the guest bedroom, she might have an extra moment to hold him off as she maneuvered to the side of the bed, putting herself in the bed between the door and Claiborne. I remind you, all of this is over a cell phone, but people have killed for less. And so the final crescendo of this act of give me my phone, no, give me my phone, no, I'm going to take it from you. Claiborne grabbed a hold of Lucille, pushing her down on the bed. And he will describe to you, as he already has in other venues, that they began tussling. Me on top of her, her on top of me. He climbed on top of her, all while Lucille still clung to his phone. He dug his knee into her ribcage, placed his right arm across her shoulder, pinning her down. Fearing for her life, Lucille fought back. She bit the arm, the wrist that was pried across her throat. She scratched his legs that were folded as he was on top of her, the only thing her arms could grasp to. And then she used her free left hand to swat him in the head, a move that ultimately saved her life as it stunned Claiborne enough, causing him to fall back into the dresser, knocking his stuff down. But now in full fear and realizing this man was not going to stop, she let go of the phone. She got the hell out of the bedroom and she ran and she called the police for help. Let me tell you that again. She called the police for help. She's on trial. Now the officers, when they arrived, they based their arrest on the more apparent injuries that you're going to see in the pictures to Claiborne. Injuries that we now know are consistent with those of an attacker, not a victim. A bite to the wrist, which he used to restrain, choke, and pin Lucille. Scratches to his legs, which would only occur from a top-mounted position. And a smack to his head, a final defensive blow to stun an on-top attacker. You're going to hear from an officer, or at least I expect you may, Officer Trant, who investigated all of this. He didn't see anything. He arrived late. He took statements. He submitted this case the same day. And the prosecutor's office charged it the very next day. No further investigation needed. And you may or may not hear from Lucille, and that will be a decision we make later. But I want you to put yourself in Lucille's shoes. The taking the phone scenario is one thing, but having someone physically attack you in order to get their phone back, and again, this is somebody you've lived with and been married to for 40 years. This is not the first altercation you could possibly have in a marriage of 40 years. Whether it's arguing over the kids, the dog, or how you do the dishes, there's other ways to resolve arguments. Claiborne could have solved this differently, and he chose violence. Lucille didn't have much choice on how she would respond. I think her response wasn't unreasonable at all. I think she escaped a physical attack by appropriate means with an appropriate amount of force. And she immediately called the police for help. Which is why after you hear the evidence in this case, and now don't be surprised, you're gonna hear a varying version of those events from this side of the table. But after you hear it all, I want you to make a decision. And I want it to be the same decision that you have for Lucille right now. That she is not guilty of this. And by her entering this not guilty plea and maybe choosing not to say anything else further, I don't blame her. She called the police for help and she's still here today. Thank you.
Ready for a witness, counsel.
Your Honor, the people call Cleavon Evans.
Thank you, Ken. Mr. Evans, all the way up front, sir. So watch your step on this incline ramp right here. Would you raise your right hand for me, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Have a seat right here. Settle in that chair. All right, Ms. Mandernack, when you're ready.
Thank you, Judge. Good morning, Mr. Evans.
How you doing?
Good, thank you. Could you please restate your name for the record?
Cleavon Evans.
Cleavon Evans, okay. And just briefly before we begin, if I talk too fast, because I know that's a habit of mine, or if you don't understand a question, just stop me and let me know. If you don't understand a question, that's totally fine. Just let us know. If you can't remember something or you're not sure, just let us know, okay? And the last thing I'm gonna say is please keep your voice up and please verbalize your answers. So what I mean by that is make sure your answers are yes, no, I don't know, no head nods or shaking, because the microphones can't pick all of that up. And the microphones also need to pick up our voices, so I want you to shout at me, okay? All right. So I'm gonna take you back to February 7th, 2024, at about 8 a.m. Where were you that day?
At home,
Okay, where's home?
43685 Forestdale Drive.
Okay, and is that in the is that in the township of Van Buren, County of Wayne?
Yes,
Okay, and can you describe your home for us?
4-bedroom,
4 bedrooms? How many stories?
2.
2? Okay, and who lived there with you at the time?
My wife and my son,
Okay, what's your wife's name?
Lucille Evans.
Okay, do you see Miss Evans in the courtroom today?
Yes,
Could you please point to her and tell us something that she's wearing?
she wearing glasses, the hair, and the ball right there.
Your Honor, I asked the record for
Noted.
identification. Thank you. And you said your son also lives with you. What's your son's name?
Chancellor Dominic Evans,
Okay, and how old is he?
32.
Okay, was he home on that day, February 7th at about 8 a.m.?
No, ma'am.
Okay. And on that day, was there an incident? Did something happen that brings us to court today?
Yes, ma'am.
Okay. Where were you in the house when the incident began?
In the guest bedroom,
In the guest bedroom? Okay, and where's the guest bedroom in the house?
in the back of the house,
In the back of the house?
2nd floor.
Second floor, back of the house? Okay. And how would you describe your relationship with Miss Evans at this point?
We were going through a divorce. We already both had filed. So we was on the outs.
Okay, and I'm sorry, can you just keep your voice up? I want you to shout at me.
Okay.
And you can bring the microphone a little bit closer too.
We both had filed for divorce, so we was ending our relationship.
Okay, you were still living together though?
Yes, in separate bedrooms.
Okay, what bedroom were you sleeping in?
The guest bedroom,
Okay. What bedroom was she sleeping in?
the master bedroom,
Okay, where's the master bedroom?
at the beginning of the steps in the front of the hallway there,
Okay. And is that on the first or second floor?
2nd floor.
Okay. And did you have your phone with you that morning?
My phone?
Yes.
Yes,
Okay, did something happen with the phone?
yes.
What happened?
After she entered the room, she grabbed my phone.
Okay, so I'm sorry, you said that you were in the guest bedroom?
Yes,
Okay, how did she enter the room?
through the door.
Okay, did she say anything when she entered the room?
Yes,
What did she say?
you're going to jail today.
I'm sorry?
You are going to jail today.
Okay. Did you say anything in response?
I asked her why.
Okay, and what did she say, if anything?
She just kept saying, you're going to jail today.
Okay, and what happened next?
She came over and I was between the bed there, and when she grabbed my phone, was laying on the bed, was taking an update. She grabbed my phone and ran out the room with it,
Okay, and where was your phone when she grabbed it?
laying on the bed,
Okay, and where were you?
sitting on the bed.
Okay, what happened next?
She went downstairs with the phone. I went behind her to get my phone.
Okay. Where did she head downstairs?
Downstairs bathroom.
Okay, and what happened next?
She put my phone in the sink and cut the water off.
Okay, did you see her put your phone in the sink?
Yes, because I didn't let her shut the door.
Okay, how did you prevent her from shutting the door?
Put my feet in the door.
Okay. Did she say anything during this time?
No, she did not.
Okay, were you saying anything at this point?
I just reached in and got my phone.
Okay. And what happened next?
I went back up to the bedroom.
Okay, and again, where's the bedroom?
Upstairs on second floor in the back.
Okay. What happened when you got back to the bedroom?
She followed me there.
Okay, did she say anything when she was following you?
You're going to jail today.
Okay, what happened next?
She came and then she came over where I was sitting on the bed and she struck me side the head.
Okay, so what were you doing when she struck you on the side of the head?
I had sat down on the bed.
Okay. When she struck you on the side of the head, do you remember what side of the head she hit you on?
My left side.
Okay. Did she say anything as she struck you on the left side of the head?
No,
Okay. And what happened next?
I grabbed the arms,
Okay, why did you grab her arms?
keep her from hitting me again.
Okay. Did she say anything?
She said I was going to jail today.
Okay, and where on her arms did you grab her?
Around her wrist.
Okay. And what happened next?
Okay, we struggled because she was pushing me, I was pushing her.
I'm sorry.
We was pushing each other on the bed there.
Okay, can you describe how you're squishing each other?
Rolling towards one way, the other, one way to the side, the other side. All right.
Okay, was any furniture damaged?
Yes, and these rolling and moving we was doing, the dresser top was kicked over.
Okay, how was the dresser top kicked over?
Her feet,
Okay, and when did she kick when did it get knocked over by her feet?
while we was rolling on the bed there. It's
Okay.
right beside the bed.
What else happened while you were rolling on the bed?
Really, just got on up. I tried to get on up to get out the room and we were still tussling and I'm still holding the arms, keep her from hitting me.
How did you try to get up?
Just pushed.
Okay, and what happened when you tried to push her?
And she tried to do everything to keep me from getting up.
How did she try to prevent you from getting up?
With her legs, she was hollering, screaming,
Okay. What was she saying?
I'm going to jail.
Okay. Did you have any injuries?
Yes, I did.
What were your injuries?
She bit me in this movements. I don't know how she bit me. She scratched me on my legs and my arm. She took my glasses off my face and twisted them. broke them up.
Okay. What happened next?
From there, we had already struggled to the door of the bedroom. All right, there I let her go,
Okay, why did you let her go?
because that's when I realized she had bit me.
Okay. What happened next?
I asked her, we need to stop. She walked behind me and said she's gonna choke me and start pulling my chains.
Okay. Can you describe the chains?
They're small, maybe 15, 16 inches.
Okay, did she say anything when she walked behind you?
Yes, she said, you're gonna choke me.
Okay.
So I'm gonna choke you.
What happened next?
The chains broke. All the chains broke.
Okay, and what happened after the chains broke?
I told her we need to stop this. All right. She said, I'm gonna call the police. I asked the police to.
Okay. And what happened next?
She went and called the police.
Okay, did you ever call the police?
I couldn't call the police. My phone was still taking an update.
Okay. And how many phones do you have?
One,
One, what kind of phone is it?
Samsung.
Okay, and is that the phone that was updating?
Yes.
Okay. Was the phone damaged by the water?
No.
Okay. And are you able to use the phone while it's updating?
No.
Okay. Judge, I'm showing defense counsel people's proposed 1 through 6. Judge, may I approach the witness, or may I approach Madam Court Reporter?
Sure.
Judge, I'm asking the court reporter to mark these as corresponding pictures. Let me just, I'm sorry, Your Honor, I'd ask for just a brief indulgence. Judge, may I approach the witness?
Sure.
Thank you. Mr. Evans, I'm showing you what's been marked as People's Proposed Exhibit 1. What is it I'm showing you?
Guest bedroom.
Okay, do you know who took this picture?
Policeman did.
Okay, and is that a clear and accurate representation of how the bedroom looked after the incident?
Yes, ma'am.
Okay, I'm showing you People's Proposed Exhibit 2. What is it I'm showing you?
The bedroom with all the dresser knocked over and stuff.
Okay, is it a picture?
Yes,
Okay, is that do you know who took the picture?
the police did.
Okay, is that a clear and accurate representation of how the bedroom looked after the incident?
Yes, ma'am.
Okay. And I'm sorry, and did you personally see how the bedroom looked after the incident?
Yes,
Okay. I'm showing you people's proposed 3. What is it I'm showing you?
where she bit me,
Okay, and is that a clear and accurate, who took the picture?
police,
And is that a clear and accurate representation of the bite mark after the incident?
yes, ma'am,
Okay. Showing you people's proposed 4. What is it I'm showing you?
where she hit me upside the head,
Okay, and is that, who took the picture?
police,
Okay, and is that a clear and accurate representation of how your face looked after the incident?
yes,
Showing you people's proposed 5. What is it I'm showing you?
chain she broke,
Okay, and do you know who took the picture?
police did,
Okay, is that a clear and accurate representation of how the chain looked after the incident?
yes,
Okay. Showing you people's proposed 6. What is it I'm showing you? Okay, and did you see her arm, Miss Evans' arms after the incident?
no, I did not,
Okay. Your Honor, at this time, I move to admit people's proposed 1 through 5.
Any objection, Mr. Kelly?
My only objection, Your Honor, would be the authenticity of who photographed these and whether or not they were photographed as part of an investigation of police. I believe that only an officer would be able to testify to that, and we don't have one present to do so.
Response?
Judge, we don't need an officer because complaining witness testified that he has personal knowledge, and he testified that they're clear and accurate representations of the images that he has personal knowledge of. So I don't think there's a foundation issue.
Anything else, Mr. Kelly?
I don't have a huge objection just to the statement that these are clear and accurate representation of the room that were taken by law enforcement after the incident. I mean, these are essentially a crime scene photo. If they're saying, are these just a picture of his room, that's one thing. But whether they were part of a police investigation, I think that's a separate issue for foundation.
Judges, would the court like me to respond?
No, he said the officer took them.
Yes, Judge. As the court knows, as long as the person authenticating the photographs has personal knowledge and can testify that it's a clear and accurate representation, I do not need the person who took the photo present.
Is your objection just the phraseology of crime scene investigation photo?
Whether or not it's part of something the police took or not, I guess would be my issue.
Okay.
And I mean, I will explore this certainly on cross-examination,
Okay.
whether it's an accurate
Okay,
description.
all right, I'll allow him.
Thank you, Judge. Judge, permission to publish?
Yes.
You ready? Yep. And, Your Honor, may I approach the witness again?
You may.
I'm just a laser pointer. Should reach. You have to hold the button down. Got it? And if you need to get over your.
Joe, don't chase that light. It's not real.
Yeah, we don't have any cats in here, right? Mr. Evans, I'm showing what's been admitted as People's Exhibit 1. Can you tell us what we're looking at?
looking at the guest bedroom,
I'm sorry, can you repeat that, please?
the guest bedroom,
The guest bedroom? Okay, and is there anything different in the guest bedroom how did the guest bedroom look before the incident?
oh, it was all straight, the cabinet was not, the top was not knocked over and none of that,
Okay,
Right.
can you show us what was knocked over?
that part right there.
Okay. And then I'm gonna show you what's been admitted as People's Exhibit 2. Again, is this how the room looked before the incident?
This would have happened after the incident, yes, there's my glasses there, that she tore up, that, not just the lens, because the frame was all over in there. All right, and all that was knocked off that dresser.
Okay, and I'm sorry, can you repeat the part about the glasses? I didn't quite catch that.
That's just the lenses. The
Okay.
frame I couldn't find at that time. All right, which I found later after I moved this stuff over here.
Okay.
The frames was over in there, but that's just the lenses that she twisted out the glasses.
Okay. I'm showing you People's Exhibit 3. What am I showing you?
You showed me where I was bitten at. It's a
Okay.
bite mark.
Did you have that mark before the incident?
No, ma'am.
Okay. All right, I'm showing you People's Exhibit 4. What am I showing you?
Where she hit me at,
Okay, are there any marks or scratch or?
right there. You can see where I'm bruised at, right there.
Okay. All right, what am I showing you?
Use the chain she broke off my neck.
Okay. Judge, may I approach?
Sure.
Or may I have continuing permission to
Yeah,
approach?
go ahead.
Judge, I have no further questions.
Mr. Kelly, cross.
Yes, sir. You put that picture back up there, proposed exhibit 2?
Here, I'll just leave.
Well, does the juror have a copy of it?
No,
Hard copy?
no, they don't have a hard copy. I can put it back up for you.
My picture is a little bit clearer than yours. Just want to show you, counsel. Same thing. Yeah, this is true. Just a little bit more clear.
Here, I can just. All right, so here, I've got. Yeah. Heather, can you please? So I've got,
All right.
I've got 1, 2, 3.
Private
4,
display, Heather?
5. Do you want?
I just want the room. Yep, right there's fine.
Do you want to move that? Do you want to move it?
Mr. Evans,
Yes, sir.
so you just testified that this was a clear and accurate depiction of the room after the incident. Is that correct?
Yes, sir.
This is exactly how law enforcement saw it?
Yes, sir.
Did you change anything about how this looks?
No, sir.
All right. I want to direct the juror's attention, presenting exhibit 2. Can I publish this? to the
Sure.
jury? I want you to pass this around. Take what I've handed you, turn it upside down, and if any of you can read the title of the red book that's on the bed. Mr. Evans, do you know the name of the red book that's on the bed?
Jesus called.
What was that?
Jesus.
Jesus,
I don't know. I don't
Did you say
remember.
Jesus calling?
Don't know exactly.
the book Jesus Calling was left out on the bed?
Objection, Your Honor, complaining witness just testified he doesn't remember the name of the book.
He did.
Did you put the book there?
No,
It was there as a result of the altercation?
it's been on my bed all the time.
And it was there during the altercation that you and Miss Evans were on that bed tussling over, it stayed there?
Yes, it was on the bed all the time.
Okay. You also took photographs before the police arrived at the bedroom,
No, I
didn't you?
did not.
Did you show police photographs on your phone?
No, I did not.
So do we have access to I guess I would need the officers here, but there's the body camera footage. Just leave it up there for now. But your testimony is that you didn't take any pictures of the stand.
No, not for the police came.
And this book was there the whole time.
Book's been on my bed for a while.
All right, let's go back in time. Yes, you can take this back. You stated that you were tussling with Miss Evans, correct?
I was defending myself, sir.
Well, you previously stated you were tussling,
I said I was rolling on the bed.
but you used the word tussling.
No, I did not.
Under permission to treat the witness as hostile at this point?
You can, but he never used the word tussling today.
Rolling back and forth across the bed, is that correct?
That's what I said.
All right. Mr. Evans, I have previously cross-examined you, haven't I?
Objection, Your Honor, relevance?
You
What's
talking about
relevance?
at the PPO?
I'm sorry.
Hold on. What's the
He
relevance?
he has the ability to answer. I
Not
don't,
until we deal with an objection that's on the floor. What's the relevance?
I'm gonna go for an impeachment, of whether or not he's used the word tussling.
Why don't you just ask him that?
All right, did you previously use the word tussling
No,
in
I
a
did not.
PPO hearing?
No, I
Objection,
did
Your
not.
Honor, relevance. I would ask that the court instruct the jury to strike the comment about the PPO.
No, I'll develop more foundation on the PPO. Let me do that first, Your Honor, and I'll spend more time on the PPO.
Judge,
Well, you may or may not. You're gonna have to convince me it's relevant to talk about the PPO at the criminal hearing.
Did you file a personal protection order because of this incident?
Yes, it did.
And did you go in front of a judge on that incident?
I'm
Yes.
sorry to interrupt, Judge. Maybe we should do an in-camera.
Okay,
Thank you, Judge.
come on up. You guys okay? You want a break? Okay? Back on the record, continue when you're ready, Mr. Kelly.
All right, Mr. Evans. Have you ever been sworn in as a witness in a court proceeding other than the one today?
No. No. Except the one you had,
Sorry,
except the one, the PPO?
is that a yes?
Yes.
I mean, did you give testimony in that hearing?
Yes.
And as part of your testimony, did you describe an action such as tussling with Miss Evans on the date of this incident?
I don't remember saying that, sir.
All right. If I showed you a copy of the transcript, would that refresh your recollection?
Mhm. If you say it's a copy on the transaction,
I'm sorry?
you say if it's a copy,
Yes. If I showed you a copy, would that refresh your recollection?
not really, I don't remember saying that.
May I approach the witness?
Sure.
Your Honor, I do have a quick objection. I know defense is refreshing your recollection. In this case, if defense is refreshing your recollection, then there could have an issue because complaining witness testified that seeing the transcript would not refresh his recollection.
Let me explore that a little bit.
Thank you.
Evans, can you see what I
Hold on,
handed you?
hold on. Let me try something. Mr. Evans, you understand that it's certain hearings, there's a written transcript prepared,
Yes, sir.
which is a word by word
Yes, sir.
capturing of the testimony.
Yes, sir.
If you were to look at a transcript of that prior hearing, do you think that might refresh your recollection as to words you might have used or might not have used?
I might not use. Could be a possibility, sir, but I don't recall using that word.
Okay, well, my question is, if you looked at a transcript, here was the question that was asked and you read that, and then here's the answer, you think that might refresh your recollection as to what particular words you did use?
No, sir.
Okay. Go ahead, respond to her objection.
Your Honor, I think it's still relevant. I think the court could take judicial notice that there was a transcript prepared in a circuit court matter here that he stated he did testify to. And that the term to provide the basis for that, I guess, maybe I'll move this as substantive proof of that evidence that contradicts his statement as to whether or not he gave a statement in a previous hearing.
Response from the people?
Judge, I believe that the proper court rule we're looking for here is impeachment by a prior inconsistent statement. And I'm sorry, I'm just thinking real quick. So of course, as the court and defense counsel know, the extrinsic evidence cannot be admitted, but I would ask the court to limit the use of the transcript for impeachment purposes only regarding the prior inconsistent statement and in accordance with the court's instructions that we have. I'm sorry, the court's instructions during the in-camera review we have in the back.
All right, we have objection.
You, no objection to that?
No.
Thank
Okay,
you, Judge.
go ahead, sir.
Mr. Evans, can you read what I've handed you specifically at lines 10 and 11?
Judge, I'm sorry, I don't think it can be read into the record again.
No. I don't think you were, just read it to yourself.
Read
sir.
it to yourself, I'm sorry. And I believe up to line 12. Do you see where the word tussling is used?
And also she rolling back and forth in the bed with her shoes.
I understand. But does that, now that you've had an opportunity to review this, does that help you recall your previous testimony?
No,
We'll just keep on going. Why didn't you let her just take the phone?
because it's my phone. Why is she gonna take my phone?
Were you worried about what she was gonna do with it?
No, I wanted my phone. I didn't want her phone.
Did it make you angry?
No, all I wanted was my phone, sir.
Where was your son during this?
At work, I guess. He wasn't there.
Does he still live with you, the house with you?
No, he does not.
You stated the bite to your wrist, you weren't sure how it happened, is that correct?
Yes,
Could it have been when you were tussling?
it was
Objection, Your Honor,
when we
call
was
for
rolling
perspective.
back and forth.
I'm sorry, withdrawn.
Thank you. Was she, when she got downstairs to the first floor bathroom, was she able to lock the door?
No,
And why not?
my foot was in the door,
And where was she inside the bathroom? Was she,
behind the door.
and did you have to use your body to keep the door open?
No, my foot kept it open.
But it's true that you followed her back upstairs and she never
She
gave you
followed
her phone
me
back.
back upstairs. I did not follow her back upstairs.
She still had your phone at that time.
No, she did not. I had my phone.
And
I
she,
reached in the door, in the sink, which is right at the door, and got my phone.
and she ran back upstairs and you went after her?
No, I did not.
Objection, Your Honor, it's been asked and answered.
I'll allow for clarification.
And where is your bedroom?
All the way in the back, on the second floor.
Is that where you had this altercation with her?
Yes,
And where was she in that bedroom when you started tussling with her?
I didn't start tussling with, she started tussling with me.
Did you ever previously tell your wife that you were going to burn the house down with her inside?
No,
Objection, Your Honor,
It's already
or
answered.
me. I'd ask that that is withdrawn.
It's already answered. Said no.
Thank you, Judge.
Jevons, did you get any medical treatment for the injuries you sustained?
no, I did not.
Did the police ask you if you needed it?
Yes,
And do you still reside in that home?
yes, I do.
Does your wife Lucille reside there?
Objection, Your Honor, relevance.
What's relevance?
I'd want to know if they do or not. I mean, if the
I
state,
don't really
state
care
of
what you
affairs.
want. I want to know what your argument is on the relevance.
I think it's relevant to whether or not there's been any further episodes or contacts between them.
And Judge, oh,
Disagree.
thank you, Judge.
I'll withdraw. Are you aware that your wife was injured during the altercation?
No,
Would you be surprised to learn that she was?
No,
Have you ever had a physical altercation like this with your wife before?
Objection, Your Honor, relevance of 404B.
Response?
Withdraw. I don't have any further questions this time. Thank you.
Any redirect?
Very briefly, Judge. Mr. Evans, how did the you said that, you just testified that Ms. Evans is the one who started the physical altercation upstairs. Can you describe how she started it?
she came into the room and said, "You're going to jail today." That's how it started.
Okay, what happened next?
I asked her why. She didn't give me no answer. She just kept saying, "You're going to jail today."
Okay, did she physically strike you?
At that time, no.
Okay, when did she physically strike you?
When we came back upstairs,
Okay, so you come back upstairs. What happens when you get back upstairs?
that's when she strikes me when we get back upstairs, because I got my phone out the sink
Okay, how does she strike you upstairs?
with her hand
Okay, and where does she hit you?
on the left side of my face.
Okay, had you physically touched her before that?
No, ma'am.
Okay. Had you threatened to physically harm her before that?
No, ma'am.
Why didn't you get medical treatment?
Because I figured I can do it myself.
Okay. Your Honor, I have no further questions.
Recross, Mr. Kelly?
No recross.
Sir, you can step down. Watch your step on my right. Man or neck?
Your Honor, the people have no further witnesses.
All right. Thank you, sir. Mr. Kelly?
Yes, at this time, Your Honor, call Lucille Evans to the stand.
Ms. Evans, come on up. Watch your step on my ramp. Ma'am, if you'd raise your right hand for me, do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? Have a seat over here. Settle in that chair.
I'm sorry, Judge, I would ask for just a brief moment so that I could sequester.
Sure,
witness.
sure. Okay, Mr. Kelly, when you're ready.
And I'm sorry, Judge, one more quick as I approach.
Sure.
Okay. Ms. Evans, thank you for being here today. I know it was not by your choosing. You go ahead and state your full name for the record.
Lucille Maxine Pickett Evans.
You just saw a gentleman leave the courtroom and Claiborne Evans. Who is that gentleman to you?
He is my husband of 41 years, 3 months and 6 days.
And taking you back to the date of February 7th of 2024, where were you on that date?
I was at home, 43685 Forest Hill Drive.
Is that the same home you share with Mr. Evans?
Yes, it is.
How long have you both resided there?
Since the home was purchased, and so it's been almost 12 years.
And your adult son also lives there with you?
Correct, he was at work.
Okay. So you've heard some of the testimony, a lot of the testimony today about what happened that day. I want you to tell the jury what happened around in the early morning, around 8 a.m. on February 7th of 2024. Where were you?
I was in my bedroom, in the master bedroom, first bedroom. at the top of the stairs.
All right. And where was Mr. Evans?
He was in his bedroom, which is toward the end of the hall.
At some point, did he come into your bedroom?
He did come into my bedroom. He has a habit of,
Objection, Your Honor, that was leading.
It was. Go ahead.
Can you tell me what happened next?
what happened next is he came into my bedroom. He walked into the room, completely into the room. He pointed his finger at my face as he has continuously done. He told me that he's going to take every dime it is that I have worked for. He basically indicates he's gonna take my money, he's gonna go on with someone else, and he's gonna get rid of me. He said that over and over. I did not apply for divorce. He applied for divorce against me.
Okay.
That was inaccurate when he said
Objection, Your Honor.
I'm sorry.
All right, so at some point, does he leave your room?
He does. He says those things to me. He leaves my bedroom.
And then at some point, do you leave your bedroom?
I do.
And where do you go?
I go to his bedroom and he's been gone.
And what do you do?
I snatch his telephone, which is laying on the bed, because I want to see who he's been sleeping with and what's going on with all of these hotels over.
And what do you do with his phone then?
I take his telephone. I'm trying to unlock his telephone so I can look at a picture of the woman, or I could get her phone number, or I can get some kind of information or find out what's been going on with him and where he's been. So I snatched the phone off of the bed. I took off running downstairs with the phone. And as I'm running, I'm trying to open up the telephone.
And does he follow you downstairs?
He follows me. He is on my heels so close. I almost fall down the stairs. I run into the bathroom. He is still on my heels. I get to the bathroom door. The bathroom door is the type of door that pushes. It's a push, you push it in. It's not a pull out. I'm in the bathroom. He is on the door. He didn't put his foot, he is banging the door. It's a powder room. It's a small room. I'm trying to open the phone and he's.
Ma'am,
All right.
I gotta stop. I know you're emotional. I understand that, but the way this is supposed to work was a question and answer.
Let me
Yes,
ask
sir.
you one more
So,
question, okay?
so let your attorney ask the question.
Yes, sir.
He knows what information he wants to get out of you. So
Yes,
he'll
sir.
ask the questions.
I know you're nervous, it's all right. All right, so do you ever put the phone underwater while it's in the bathroom with you?
No, sir, I do not.
All right. Does Mr. Evans ever gain entry into the bathroom with you?
No, he does not.
Is he able to retrieve his phone back from the first floor bathroom with you?
No, he did not.
Do you take the phone somewhere else?
I ran back upstairs with it because he was banging me with the door.
And where do you go upstairs?
Straight to his bedroom because it's a straight shot straight upstairs.
All right, are you, and where do you go in that bedroom?
I'm running around to the side of the bed and I'm trying to unlock the phone as he's on my heels.
Are you in between the bed and the dresser that was exposed in
Yes.
these pictures?
Yes, I am.
On this side of the bed?
That is correct. Yes.
All right. And does he ultimately follow you back up into his bedroom?
Yes.
And what happens next?
He is trying to snatch the telephone from me. I'm trying to unlock the phone. He grabs me by the shoulder. He slams me into the wall right near the dresser area. I still won't let go of the phone. He grabs me by the wrist, that I'm right-handed, the phone, and he swings me around. Eventually, we fall onto the bed.
And what happens once you're on the bed?
We fall onto the bed. He takes his knee, he puts his knee into my rib cage. He takes his other arm, he puts it across my shoulder area up in here. I'm right-handed. I'm saying, let go, let go. I drop the phone and I ask him to get off because he's in my rib cage. He looked at me, he brought his arm across me and he said, "Oh, now I got you." He looked really wild-eyed. I was very afraid.
And did you bite his wrist as it was coming across your chest?
Yes, I did.
And did you also strike him in the head while he was on top of you?
He was in my rib cage. I bit his hand so that I could get him up out of my rib cage. He didn't get off. He looked at me as he was going to kill me. And I started to claw to get him off of me. he just leaned his head back. And so I clawed at his legs area because he had on his robe and his underwear. I clawed at his leg area. That didn't do it. So then I clawed at his face. When I did, I think that's when the glasses, but he jumped back and he jumped off of me.
And when he jumped off you, what happened?
Everything fell off of it's a topper that sits on the dresser. It's not attached, it's just a topper. Everything fell off and I ran out of the room.
And you dropped the phone at that point?
I dropped the phone when he had his knee in me and I asked him, I've been dropped the phone, but he wouldn't get off.
And what did you do after you were able to get out of the room?
I ran to call 911, went and called the police. I called Van Buren Police.
Why did you call the police?
I told the police that I had been assaulted and he had his knee in my rib. I was injured and he had his arm across my neck to choke me.
Thank you, Ms. Evans. Lastly, did you feel that using that force was absolutely necessary?
Absolutely.
Thank you. Nothing further.
Cross, Ms. Benedict.
Good morning, Ms. Evans.
Good morning.
You testified earlier that the incident began when you took Mr. Evans' phone, correct?
No, I testified the incident began when he came to taunt me.
Okay. Why did you take his phone?
I took his phone because, may I answer?
Please do.
Because for the last 4, 5, 6 months, he has been at hotels for 3 to 4 nights a week. And I have evidence because I've seen it on his charge card statement.
Okay, oh, go ahead, I'm sorry.
And that's why I took his phone to see what he had been doing and what was in it and who he was dating.
Okay. And is it fair to say you were upset that he was dating other people?
Yes, ma'am, it's fair to say that.
Okay. Is it fair to say you were angry that he was dating other people?
Not angry.
Okay, so you've been with him for how many years did you say?
I've been with him for over 40 years. I was upset that he was disrespecting me. He's dated other women before.
Okay,
I wasn't angry.
And I'm sorry, ma'am. So you're not angry that after dating him for or after being married to him for all these years, after living with him, you're not upset that he's sleeping with other women, correct?
I'm not angry. I am upset and I am disappointed.
Okay. And you testified earlier that after you grabbed his phone, you ran downstairs, correct?
Yes, ma'am.
And you testified that you were trying to get in the phone, correct?
Yes, ma'am.
And you testified that you were trying to get in the phone because you wanted to find the contact information for the other woman, correct?
Or whatever I could find. I wanted evidence.
Evidence that he was cheating and being unfaithful, correct?
Further evidence.
I'm sorry, that was a yes or no question.
Yes.
Thank you. And you testified that after you ran out of the bathroom, you still had his phone, correct?
Yes, ma'am.
Okay. And you testified that you were still trying to get the information out of the phone, correct?
Yes, ma'am.
And you testified that you ran upstairs into Mr. Evans' bedroom, correct?
The furthest room away, yes, ma'am.
Okay. And you testified that in the bedroom, you didn't give the phone back because you were trying to still get into it, correct?
Yes, ma'am.
Why didn't you give the phone back to him?
Because I wanted to see what was in it, ma'am.
Your Honor, I have no further. Oh, I'm sorry. Did you grab the chains around Mr. Evans' neck?
During the altercation, I may have grabbed the chains. I don't specifically recall when they were grabbed.
Your Honor, I have no further questions.
Mr. Kelly, your witness.
I don't have any further questions.
Okay, ma'am, you can step down. Watch your step. You're all right. Any other witnesses from defense?
None.
Ms. Mandernack, rebuttal?
I'm sorry?
Rebuttal witnesses?
No, Your Honor.
All right. What's your feelings? You want to do closings or you want to break and do final instructions?
Closing.
Then instructions? All right with that, Ms. Mandernack?
Judge, I would just ask for a quick
Sure.
bathroom break.
Yeah. You guys okay for a couple? You all right? Okay.
Thank you, Judge.
Yep. Ma'am.
Thank you, Judge. I just asked for a brief indulgence while I look at my computer.
Sure. Go ahead.
Good afternoon, ladies and gentlemen. It's 12:04, so we're making pretty good time. I want to thank you for listening and paying attention and keeping an open mind today. Also, if I say something that you believe is incorrect in terms of recounting what one of the witnesses stated when they testified, I want you to rely on your collective memories, because there's 7 of you, there's 1 of me. So you may remember something better than I do. So as I stated earlier, we are here today because on February 7th, 2024, at about 8 a.m. at 43685 Forestdale Drive in Van Buren Township, Michigan, defendant Lucille Evans assaulted complaining witness, Mr. Claiborne Evans. She assaulted him by striking him across the face, causing the red marks that we saw. And I'm sorry, I'd ask that you bear with me for just a moment. I guess, please. Thank you, Heather, or Madam Clerk. Thank you. So as you heard Mr. Evans testify that the incident started when defendant Lucille Evans came into his bedroom and grabbed his phone. You heard testimony from defendant Lucille Evans that the reason that she grabbed his phone is because she wanted to go through it. She was looking for evidence of infidelity. I submit to you, she testified that she was upset. She didn't say she was angry. I submit to you that she wasn't just upset, she was angry. That's why she was going through the phone. That's why she went and grabbed it from him when it was updating. That's why she ran downstairs with it and was in the bathroom with it, trying to unlock it and get the information out of it. She testified that she was specifically looking for the contact information of the woman that Mr. Evans was supposedly cheating on her with. Defendant Ms. Evans then ran upstairs, and this is where you have to use your judgment and make a credibility determination. I submit to you that Mr. Evans was telling the truth when he said that he grabbed his phone and he went upstairs. I submit to you that that made defendant upset because, as she said, she wanted the information out of that phone. I submit to you that Mr. Evans is telling the truth when he ran upstairs with his phone and when the defendant followed him because she wanted the phone back. You heard that the parties were going through a divorce. They were living in separate, they were sleeping in separate bedrooms, still living in the same house. That situation, I submit to you, supports Mr. Evans' testimony that she chased him upstairs to get the phone. Mr. Evans testified that once he was upstairs, defendant struck him across the face, and you saw we have the red, he pointed out the red marks on his face that are consistent with his testimony of being struck across the face. He also testified that he was bitten in the wrist. And again, we have a picture of the bite mark. This supports his testimony, supports his version of events. We have a picture of the bedroom where this happened. I submit to you, defendant testified that when she ran back upstairs, she still had the phone in her possession. She testified that she ran to Mr. Evans' bedroom. I submit to you, why did she run to his bedroom? Why wouldn't she run to her bedroom where it would supposedly be safer, especially if she's in fear of him at this point? In the picture, we see the knocked over cabinet, which is again consistent with Mr. Evans' testimony. And we see the broken glasses, which are again consistent with Mr. Evans' testimony. Additionally, Mr. Evans testified that at one point after they had gotten up off the bed, defendant came behind him, said that she was going to choke him and grabbed the necklace or the chain that he was wearing. And we have a picture of the broken chain, which again is consistent with Mr. Evans' version of events. So I'm not going to bore you by reading at you, but Here, defendant is charged with 1 count of domestic violence. As the judge stated before, in order to prove domestic violence, I need to show a couple things. First, I need to show that there was an assault or an assault and battery. Your jury instructions, and as the judge said earlier, an assault and battery is a forceful, violent, or offensive touching of a person or something closely connected with him and her. So an example of something closely connected with him or her would be the chain that Mr. Evans was wearing because it was on his person at the time. And the second thing that I have to prove that this touching was intentional. It was not accidental. So it happened on purpose. Defendant didn't fall into him and grab the chain on her way down to try to stay upright or anything like that. Also, I have to prove that the parties were married at the time. You've heard testimony from both parties that they were married at the time of the incident. You've heard testimony from Mr. Evans that defendant initiated the physical contact when she struck him across the face, causing the red marks. The judge is also going to tell you that an assault does not have to cause an actual injury. Here, we do have minor injuries on Mr. Evans. He has the bite mark on his wrist. He has the red marks on his face. And he has the broken chain. But you don't need to find actual injury. The judge is also going to tell you that testimony is evidence. And again, I've said this so much, testimony is evidence. We don't have a magic way of figuring out who's telling the truth. If we did, we wouldn't need you guys. You're here as the finder of fact to make that determination. You're going to rely on the factors the judge weighed out earlier. I'm not going to reread them to you regarding credibility. But I submit to you here that defendant is not being truthful. I submit to you that we have evidence of that based on her own testimony, that she is mad about Mr. Evans' infidelity. That's why she wanted to go through the phone. And she was honest with us. She didn't just want to go through she didn't just want to take the phone with her, She wanted to get the name and address and more proof that Mr. Evans was cheating on her. I also want to touch on what we talked about earlier regarding a bad neighbor who won't let you build a shed on your property or an annoying coworker. You don't have to like everything someone does in order for them to be a victim of a crime. The victim doesn't choose to become a victim of the crime. The defendant is the one who chooses that. In this case, I believe that when you go back there, when you deliberate, when you go over the testimony, when you review the picture, when you think about the pictures that support Mr. Evans' side of the story, when you think about, or when you go over Ms. Evans' testimony about how enraged she was, I believe that you will find the defendant guilty. Thank you.
Mr. Kelly.
All right. Well, pretty streamlined. It's always a tough act, and I think you got to see a little bit more than maybe I thought you would need to in this case, and that's because I certainly ran into things on my end, and that's part of the process. But I think we're all on the same page here, what likely happened. And no matter what, snatching your spouse's phone is not grounds to assault that person. When you're given the two varying versions of events, which is more specifically why I had to put Miss Evans on, because it was such a stark contrast, and I could not leave you jurors with only thinking one narrative could possibly have occurred, and having them be so different. I think you can use your judgment here to decide what was the most logical and likely scenario that these two end up tussling, rolling over on top of each other, mutually combative state. It's because she still got the damn phone. That's likely what happened here. And what she could have been enraged about, but she never got into the phone. It was updating the whole time. So it's not like, oh, I found out it was Jackie down the street that you were banging. I knew it was her. I'm gonna come up here and hit you in the head because I knew it. She never got in. She never got in. Maybe she should have never taken the phone. Maybe we should never take our spouse's phone. Sure, because we know that's likely to tick them off a bit, but it doesn't invite an assault. And I believe that Lucille was much more credible in what actually happened here. And I was curious and quite surprised that the police weren't here to talk about what they did or didn't do either. But again, it's not my burden of proof, it's the prosecutor's. And she doesn't have 3 lawyers or a team of people behind her. She's just one person, just like I am, but she does have greater resources too. And she has resources to meet this burden, which is the highest in the land, beyond a reasonable doubt. We should be falling over our seats with compelling evidence of guilt. Instead, it's at best a close call on whose testimony might be more credible. And the chain things, I don't think we ever really got to the chains. I think they likely snapped off when they're fighting and rolling on the bed. You know, I think that's probably when it happened. And I leave you with this too. And I said this in my opening. She called the police. Why would she call the police if she believed that she had just assaulted her husband and she was in the wrong? No, because a crime had occurred. Nothing stopped Claiborne Evans from being able to go out and holler down a neighbor or anything like that. He could have gone out and reported. He didn't. Why? So I remind you of your commitments and your promises that you guys all agreed to when we chose and decided that this was going to be a good fit for you. I gave you a little bit more, and I didn't have to let Lucille testify. You guys promised whether or not I did that, you wouldn't hold against you. That's why I picked you, because you'd be willing to listen to only the evidence that was presented. And when you go back there and deliberate, I think you're going to have a pretty easy time deciding, all right, we can agree on one thing here. Much one thing. These two were tussling over this phone is what the scenario was. And that there are other ways that Claiborne Evans could have resolved the situation than turning it into a physical state. And the injuries that he sustained, a bite to his wrist, a smack to the head, and scratches on his legs are consistent with him being on top of her, putting his arms across her body. And after your deliberations, you're going to come back here, and I'm going to know you did the right job, because you're going to find my client not guilty. Thank you.
Thank you both. So I'm going to guess, just based on past experience, we can probably have the final instructions ready to start you deliberating within 30 minutes. Do you want to just hang out, give you the instructions, and that's it? Or do you want to take a lunch break and we'll give you instructions when you get back?
I'm sorry to interrupt, Judge. Do I get a brief rebuttal?
Yes.
Okay, I just want to make sure.
When I remember it, yes.
Okay, thank you, Judge.
What do you think?
We got a half hour, right? You said?
I'm thinking it's going to be a half hour before, after she's done with the rebuttal.
Oh,
Then we're gonna give you a break either in the jury room, or we're gonna send you back out to grab some lunch, and then we're gonna work and get those final instructions nailed down.
Sure.
Keep working. I'm okay either way. You're not pleasing me. I just want you guys to be happy. Keep working. Okay, all right. Rebuttal.
Thank you, Judge.
Glad you thought of it.
I knew you wouldn't forget.
I never forget when I'm reminded properly.
All right, I'm gonna keep this very brief. So I agree with defense counsel that you cannot physically assault someone for taking your phone. However, I don't think that that's what happened here. I think that based on defendant's testimony, defendant testified that she knew from other methods that Mr. Evans had been unfaithful, or she had reason to strongly suspect it. I don't think she needed to get into the phone to prove that he was unfaithful. I think she was trying to get into the phone to get the other woman's information. We talked earlier about we talked during jury selection about the example of how much evidence, right? And I have to prove beyond a reasonable doubt that it happened. But again, and I sound, this last thing I'm gonna say is I promise, testimony is evidence. We talked about the example during selection of someone breaking into your house and stealing a vase with no witnesses, no cameras, no fingerprints. The fact that there's only one witness doesn't mean that the crime didn't occur, and it doesn't mean that the defendant can't be found guilty if you, the finder of fact, believe that testimony. We also talked about the boxes, or in this case, envelopes of evidence. I didn't want to put the pictures into an envelope. It doesn't matter how much in terms of quantity evidence there is. If you believe the evidence that I have put on, if you believe Mr. Evans' testimony, which I argue is corroborated by the pictures, then you can find defendant guilty. And I believe that in this case, I'm sorry, and defendant, or Mr. Evans did not need to call the police. I submit to you that the reason that defendant called the police is because she told Mr. Evans at the beginning, she told him he was going to jail repeatedly. I submit to you that that's supported by her calling the police because she wanted to get him arrested, possibly to gain the upper edge in the divorce. I submit to you that's a possibility. And I submit to you that the reason that Mr. Evans didn't call the police is, number one, he testified that his phone was updating and he couldn't. Number two, he didn't have his phone for most of the incident because Miss Evans had it. And number three, he already knew that Miss Evans was calling the police because she had stated repeatedly that she was going to get him arrested. I believe that when you take all of this into consideration, the pictures that support Mr. Evans' testimony, defendant's testimony about how she wanted to find the name of the woman in the phone, I believe that you will reasonably conclude that Mr. Evans is telling the truth and that defendant is the one who initiated the physical assault by slapping or by striking Mr. Evans across the face. Thank you.
Thank you. Joe, you want to take them up? Once again, you can leave all your stuff here. And if you need anything, Joe's right outside the deliberation room. Just knock on the door and let him know what you need. We'll get you back in as soon as we can. You can leave that. Ms. Evans, you can take a break if you want to. I'm going to keep the attorneys working. So the easiest way for us to do this, I think, is just to go through the tablet. Instruction by instruction.
Still got that.
It does, and it was at 10%.
Did it?
5%.
All right. Grab one of the jurors for now.
Yeah, I'm just gonna run the bathroom.
Yeah, go ahead. Question. Oh, sorry. One of the jurors had a question for a witness.
Oh,
They didn't tell anybody. They just asked Joe. Just asked Joe. When did we do the question thing?
oh no.
So what was Mr. Johnson's comment on his questionnaire?
I really don't want to be picked for jury duty.
Pretty tame.
Yeah, I appreciate the honesty. Yeah.
I thought my question from the jury instructions were pretty clear about timing.
when you were reading your stuff, and
Which stuff?
it should have been, you know, not where you said this should be where the elements of the crime should.
Yeah, hold
Where
on.
is that?
I'm looking at procedural instructions.
Procedural instructions, okay.
Yeah, let me find it. It's in trial procedures.
Trial procedures.
So right in
Three
paragraph.
elements of the.
Yeah.
Okay.
Yeah.
So yes. Okay. Procedural section.
Yeah. Ken's out there? Yeah, that's fine. So when Joe took him back, the question was, so when do we get to that whole question of the witness thing?
Of the what?
Witness. So he just handed me paper. I didn't look at it. He says, I think there's two different questions here.
Oh.
So my gut reaction is, we've already had closings.
Yeah.
We've rested. But I just wanted to bring it up.
They're wondering who the witness is?
No, they want to ask a question of a witness. And no,
Oh, they
And-
missed their chance.
that's kind of the way I'm looking at it. And
What's the question?
I don't know. I didn't look. I don't think that's the question. I think the question is, should we reopen proofs at this late stage in the game?
No.
I mean, we've already,
Yeah, I mean, we've already had closings.
Yeah.
I mean, it'd be one thing if we took a break before closings and they brought this up.
yeah.
Yeah, it's all right. Well, no, probably not. It's just, yeah, let's not. We're gonna stop the live stream while we have this conversation about jury instructions. Yeah, I think